of a matter by tomorrow, Lordship.
What do you want?
WPC 1119 of 24.
Mention matter. Go to the senior court.
For withdrawal.
Withdrawal.
Court.
Senior court.
Supplement.
Court number 4.
Right.
May I please your lordship, with the consent of other side, I beg to mention item number 19 and 20. I am appearing on behalf of Mr. A.R. Soon.
19 and 20.
Yes, my lordship.
On the prayer being made by Miss
B. Chauhan,
Learned Counsel appearing on behalf of
A.R. Soon.
Mr. Earson, Learned Counsel for the appellant. The matter stands adjourned to be listed
Lordship,
after
after vacation.
vacation. Both the matters released from Parthad.
Highly object.
You obtain consent from the other side. Okay.
For admission. Item number 45.
डेट टू कैसे होती है ये इसकी तो डेट टू कैसे असला पार्ट तो डेट टू फाइल
This 1 to 5. This one.
डेट टू है और दो दिन हम भी Yeah,
Hello.
Mr. Sarma.
My lord, on the last occasion, your lordship had raised a very pertinent query as to what act governed the aspect of provincialization of venture institutions. Now, my lord, I've gotten the relevant act, my lord. Before that, I would like to submit a few lines. What used to happen, that the ideal situation would have been that the government would institute education institutions and thereafter run that institution. But in the state of Assam, what had happened for a long time was that villagers in certain pockets would understand that a school is quite far away. And then they would institute and set up a school, run it, and thereafter accord recognition by the state and permission for the students to appear under the regulatory, the relevant boards. And thereafter, those schools will be provincialized. Now, my lord has gotten a copy of the education manual, man. Education manual. I just provided a copy, my lord.
Yes, yes.
Yes. Page, my lord, the older one. The newer one does not have. My lord, page 81. Page 81.
Yes.
The Assam Elementary Education Provincialization Act 1974. The word venture is missing, my lord. Because the word venture has to be looked at it from a point of view of first a school being set up by a certain pockets of villages. It has to be accorded permission to run, recognition for the students to finally appear under the relevant boards, and then those institutions would be called venture. Now, the word venture for the first time came in 2011. Prior to that, Assam Elementary Education Act of 1974, my lord, which lordship will find at page 81. Now, my lord, will kindly come to section 11. Section 11. Your lordship has seen that? Section 11, my lord, page 87. Recognition of elementary schools and their affairs. Subject to section 12. All elementary schools recognized under section 37 of the Assam Elementary Education Act 1968 shall be deemed to be recognized elementary schools by the state government. Now, subject to section 12, my lord, section 12, the terms and conditions of recognition and of grant in aid to new elementary schools, my lord, those will be venture schools, shall be laid down by the state government from time to time, provided that on the recommendation of the Deputy Inspector of Schools concerned, the state government may accord necessary recognition to such elementary schools as may fulfill the required conditions. All existing teachers and other employees of the schools, those to be appointed in any elementary school recognized under this act, except in the case of the autonomous district, shall be deemed to have been appointed by the state government in their corresponding ranks. Now, my lord, will kindly come to page 91. Page 91, my lord.
Yes.
The Assam Elementary Education Provincialization Rules of 1977 framed under the Act. Now, there are certain parameters which have been laid down for recognition of an elementary school.
Hmm.
In this regard, my lord may kindly come to page 101. 101. Rule 5.
Yes.
Conditions for taking over elementary schools. Every inhabited village shall have at least one elementary school. In a village where there are more than one schools, the minimum distance from one to the other should be 1.1 kilometer, provided there are more than 200 population in the case of LP school and junior basic schools, and 3 kilometers in case of ME, MV, and senior school. Enrollment in each of the schools shall not be less than 40 in case of lower primary schools and junior basic schools, and 90 in case of ME, MV, and senior basic schools, provided that the enrollment may be relaxed by the government in suitable cases. Number 3, the teachers in venture school may be retained at the time of taking over if they possess the minimum qualification and age for recruitment, provided that such teachers have put in at least 2 years continuous service immediately preceding the taking over of the school, and provided further that the prescribed ratio of students and teachers is maintained in the school. Number 4, a venture school should possess at least 2 bighas of land in the rural areas and half bigha of land in the urban area. This condition may, however, be relaxed by government in suitable cases. So these are the criteria, my lord. In fact, your lordship will see at Rule 5, Clause 4, a venture school.
Mr. Sharma, what
Right.
was the query put by this court on that day?
On that day, my lord, your lordship had raised a query that prior to 2011 Venture Provincialization Act of 2011, what was the relevant act putting the field?
Okay.
Now, my lord, we'll see the interesting part of this is that the conditions which have been laid down
Hmm.
in Rule 5,
Hmm.
my lord will kindly come to page 25 in the writ petition, my lord. Item number 1. Item number 1, my lord, page 25 is the policy.
Yes.
Now, my lord will see this was a policy of 1993.
Uh,
Policy in point number 1, point number 2, point number 3, point number 4, point number 5, and point number 6 are replication of Rule 5.
hmm.
Page 25 of the writ petition and page 101, bearing certain small numerical changes, are the same. The
Hmm.
parameters of Rule 5 have been reproduced in the policy.
Hmm. Hmm.
Now, while there was a rule in place, while there was an act in place, the government brought about this notification, the policy decision,
Hmm.
implementing the same criteria which have been laid down in Rule 5.
Hmm.
Now, my lord will kindly come to one of the sample orders of provincialization. My lord, your lordship will kindly come to page 43. Page 43,
The writ petition.
my lord, the
Writ
writ petition,
petition.
the writ petition, my lord, the writ petition. Page 43 is where the order of provincialization starts.
Hmm.
And page 44, serial number 11, is where one of the schools are mentioned, my lord.
Hmm.
Honaton Hevasram Girls MES School.
Yes.
Now, my lord will see the third column. It is called the date of permission and recognition.
From 1191.
1/1/1991.
Hmm.
Date of permission and recognition was accorded to the school in the year 1991 prior to the coming of the policy. And recognition and permission can only be given by the state government if it fulfills the criteria of Rule 5.
Hmm.
So it is admitted, my lord, that my schools, the petitioner schools of item number 1, 2, 3, 4, 5, fulfill the criteria laid down in Rule 5 of the Assam Elementary Education Rules 1977.
Hmm.
It was framed under the Act of 1974.
Hmm.
The recognition and permission was granted to me prior to the coming of the policy. The policy sought to implement the idea of provincialization in various schools of Assam. the government will have to satisfy this honorable court as to why the policy was framed when even there was a rule. But the basic crux remains, my lord, that my school, along with other schools, were left out of the policy decision. When it is admitted that I fulfilled the criteria as laid down in Rule 5 of the then operating rule. And now, when I was provincialized in the year 2013, the defense which had been taken by the state is that under the new Act of 2011, there is no aspect of retrospective benefits, which I cannot dispute at this stage, my lord, because the Act is clear at that stage. But when the policy came, I was squarely covered under the policy. The state could have had a point saying that I do not fulfill the criteria under the policy at page 25. Now, they have not taken that stand. And they have not taken that stand, my lord, naturally, because I was recognized and I was permitted to operate under Rule 5, which is already indicated in the writ petition, my lord. So recognition was already granted to me to run as a venture school. What was not done at that point in time was to provincialize the services of the petitioners. This is my case, my lord, that I was left out unjustly, arbitrarily from similarly situated individuals in the state of Assam. I had approached this honorable court, my lord, multiple times where the government were directed to take a reasoned order and reasoned step. At Annexure 6, my lord, is a communication between the high functionaries of the education department, which sought a detailed response as to why my names were left out. There was no response to that letter. And eventually, when I was provincialized in the year 2013, I was not given the benefits which was given to
Who had not given response to the letter?
Annexure 6, my lord. Annexure 6,
Page number?
my lord, page number 38. Page 38. If I may permitted to read the letter, my lord. In enclosing herewith a copy of representation received from Sri Nogendra Chandra Borman, who is item number 2,
This letter has not been
not been responded to.
responded.
Why my proposals were not forwarded to the government. In fact, my lord, the entire set of facts have culminated at page 79 of this honorable court in the earlier round of litigation. My lord, this is my simple, this is my case, my lord, that similarly situated schools in the year 1993 were provincialized. It cannot be the stand of the government that I do not fulfill the criteria under the policy, because those policies are replication of the rules and the orders of provincialization indicate that I was already recognized. So, which primarily means that the criteria which have been laid down in the policy were fulfilled by the schools. Because page 25 the provision to regularize and provincialize my services under the 1974 Act, read with 1977 rules, which was not done. The government waited for a policy. The policy came, the policy went. I was left out. Thereafter, in 2013, I was provincialized with no retrospective benefits. And I, in the process, have lost out 24 years, my lord, of being provincialized. Because if you, my lord,
24 years.
24 years, 1991 onwards till 2013. And my lord, to satisfy this honorable court, if your lordship kindly comes to page, your lordship had already seen page 44, serial number 11, which is Sanatan Hevashram, my lord.
Page number?
Page number 44, my lord.
Yes.
It was recognized in the year 1991, prior to the coming of the policy.
No, you have already shown me.
Yes, my lord. Then my lord will kindly come to page 46. Page 46, serial number 27, which is item number 1, my lord, as of now. Pohumara Ansolik MEM School. It was recognized in 1989 and 1990. Then, my lord, will come to page 56. Page 56, serial number 4. Athiabari Girls ME School, Athiabari, which is item number 3, right, my lord? It was recognized in the year 1985. 1985. Then my lord will kindly come to page 67. Not 67, my lord. I apologize, my lord. 71. 71.
Yes.
Page 71. Page 71, which is item number 4 today, my lord. Bamuni, Sotogirari, MES School, Village, Sotogirari, Barkanda, my lord. Permission 1989. Recognition 1991. Serial number 35.
Okay.
So it is the very admission of the state respondent, my lords, that I fulfill the criteria under the rules and under the policy pursuant to which I was already recognized, but I was left out from the entire aspect of provincialization, which ought to have been granted to me, my lord, from the year 1991. The only ground that the state had taken in their affidavit, my lord, is that 2011 Act does not have a retrospective clause, which is not disputed, my lord. However, I claim my rights for provincialization under the policy. That is my case, my lord. My lord, in fact, I have this is a judgment by the Honorable Supreme Court, my lord. This is a synopsis of the judgment, my lord. It's a voluminous judgment. It's rendered in the year 1952, 1 SCC, my lord, by a 5-judge bench of the Honorable Supreme Court, which has still managed to hold the field. My lord, there are 5 judges, and I have prepared a brief synopsis, my lord, for your lordship's ease of consideration. 1952, 1 SCC. And my lord, there was another case law which was furnished before this Honorable Court, my lord. Article 14 and reasonable classification and intelligible differentia, my lord. And my case is that I fulfill the criteria on which the other similarly situated schools were provincialized, and there was no intelligible differentia differentiating the schools of the petitioner from those of 1, 2, 5 schools which were provincialized in the year 1991. This is my case, my lord. Page number given. 19 to 1 SSC 1.
Okay. Mr. Talukdar?
My lord. That's the picture of my lord. We can just that's how in the year 1991. Subsequently, 2013, my lord, their services has been provincialized, my lord. Under the new act, my lord, 2011, my lord. And the coordinate transcripts on regarding the records of the 1991 murder. In earlier, we have filed our affidavit. And I received instruction that matter that file could not trace out like it was department. And
File could not be traced out.
Matter. We have also filed affidavit in this figure matter. And subsequently, my lord, Annex 14 page 87, my lord, the repetition, my lord, speaking order passed by the director, detailed director, my lord, stating that petitioner services was provincialized under the Act of 2011, my lord. Where, my lord, the consequential benefit of the service in the Act, my lord. In the Assam Bacha Education Institute Provincial Service Act 2000 as amended 2000, there is no provision for giving consequential service benefit, including pensionary benefit from the year 1991.
Mm.
That is from the date of recognition of the full concern, my lord.
Yeah, but the question is why earlier the petitioners' schools are left out?
That is the instruction I don't have, my lord, because my lord, the
File is not available.
my lord. And my lord, subsequently, my lord, by this honorable court, the Act of 2011 was struck down, my lord. A
Mm.
new act come into force, my lord, 2017, my lord. If you lordship peruse the new, my lord, his book, my lord. Page 117, my lord.
Mm.
Section
This
eight.
new act.
New Act, my lord, Assam Education Professional Service Teacher and Rehabilitation of Educational Institute Act 2017. My lord, page 117, my lord.
Yes.
Section 8, my lord.
Mm.
Okay. Terms and condition of service. 8.1, my lord. Subject to the provision of this act and the rules made herein after all rules including service rules and rules of conduct of discipline which are applicable to the state government servant or corresponding ranks shall be applicable to all teacher and educational institutions whose services have been or to be provincialized under the provision of the act. But 8.2 is important, my lord. The teacher whose service have been provincialized under this act will get full scale of pay and such. As salary and allowance as per norms of the state government applicable to the employee of the corresponding rank with effect from the date of provincialization of their services. As if they are fresh appointed and they cannot claim any benefit whatsoever in respect of past services rendered by them before provincialization. And in respect of pension, they shall be governed by new pension scheme applicable to the state government. It's a the corresponding rank, my lord. So under 2011 Act and also say that no consequential benefit will be received by them.
Mm.
The Act, my lord, 2017, Section 8 to also provide that. They cannot claim any benefit whatsoever and in respect of pension and other kind of. So. Other.
Yes.
My lord. So they, petition, my lord, they came from 1991, my lord.
Mm.
So subsequently, my lord, this act also 2011 Act also struck down by the honorable court, and this new act also provided that a consequential benefit of the petitioner would not claim, my lord.
Mm.
My answer and they could, if they are agreed by the 1991, my lord, they should have come earlier, my lord. They approached before this court in the year, my lord, to pass litigation in the year 2018, my lord. So subsequently, my lord, it is filed, my lord.
Mm.
In 29, 10, 2018, it's honorable court, 674 of 2011, my lord, passed order And on the speaking order, my lord, Annex 14, page 87 was passed by it and director, my lord. My most respectful service on that, and if law is clear, very clear that they cannot claim consequential benefit. If the my lord, my humble submission, that it is not maintained. Not entertain the petition, that's the tax itself, my lord, and my lord, they are not getting any past benefit, my lord.
Yes, Mr. Sharma,
My lord.
how this hurdle mentioned in the section 24 of the new act
Yes,
of
madam.
2017
My lord.
can be overcome?
My lord, my first submission in this regard would be the fact that my rights flowed under a prior act.
No, you come to
Yes.
this
That I can-
section 24 of the
Yes,
new
ma'am.
act.
Right, sir.
Repeal and savings.
Yes, my lord. The Assam Venture Educational Institutions Act 2011.
No.
Repeal and
No, 2017.
As amended by the Assam Venture Educational Institutions Amendment Act 2012 and the Assam Venture Educational Institutions Act 2013, which have been struck down in the Honorable Guwahati High Court. So all rules, orders, notifications issued thereunder shall stand repealed. However, all teachers whose services were provincialized prior to 2016, 23/9/2016 shall continue and their cases shall be reviewed as per the eligibility norms set forth for provincialization under this act.
So under this act,
My lord.
this section 8,
Yes, my lord.
section 8 bars in preferring such claims, subsection 2 especially.
Yes, my lord. The teachers whose services have been provincialized under this act shall get full scale of pay and such emoluments as salary and allowances as per norms of the state government, applicable to the employees of the corresponding rank with effect from the date of provincialization of their services, as if they are fresh appointees, and they cannot claim any benefit whatsoever in respect of past services rendered by them before provincialization, and in respect of pension, they shall be governed by the new pension scheme applicable to the state government teachers of the corresponding ranks. This is what his lordship has referred to. My lord, there's a judgment which I had furnished for this honorable court, my lord. The earlier case, my lord, 1997 6 SCC, my lord, it should be the lordship.
Please, ma'am.
637.
Chairman
Yes,
Railway
my
Board.
lord, my lord.
Okay.
My lord, the matter, the facts in that case are slightly different, my lord. It pertains to pensionary benefits which ought to accrue, my lord. If your lordship can kindly come to page 20, paragraph 20, my lord. Paragraph 20. The principle has been laid down by the Honorable Supreme Court. My lord, if I may be permitted to read, my lord.
Yes.
20. It can therefore be said that the rule which operates in futuro so as to govern future rights of those already in service cannot be assailed on the ground of retroactivity as being violative of Articles 14 and 16 of the Constitution. But the rule which seeks to reverse from an anterior date a benefit which has been granted or availed, example, promotion or pay scale, can be assailed as being violative of Article 14 and 16 of the Constitution to the extent it operates retrospectively. In B.S. Yadav versus State of Haryana, a constitution bench of this court, while holding that the power exercised by the governor under the proviso to Article 309 partakes the characteristics of the legislative, not executive power, and it is open to him to give retrospective operation to the rules made under that provision, has said that when the retrospective effect extends over a long period, the date from which the rules are made to operate must be shown to bear either from the face of the rules or by extrinsic evidence reasonable nexus with the provisions contained in the rules. My lord, my submission based on the principle which have been laid down is that the state cannot take the benefit of efflux of time. I would not have come under the 2011 Act if the state was proactive in granting me the benefits which were granted to similarly situated schools all over the state. The state, my lord, failed in that attempt to take care of our grievances. The state failed in its attempt to redress our grievances. My lord, the first instance of where we approach this honorable court, the 2011 Act was not even in force. My lord will kindly come to page 35. Page 35. My lord, this was in the year 2004.
Is 35 of?
35 of the writ petition, my lord. Item number 1, my lord. All Assam ME, MEM recognized 1991 School Teachers Association. An association duly registered with the registration so and so. Petitioner number 2 is one of the petitioners in the series of these cases, my lord, Nogendra Sondra Bormon.
Hmm.
Now, my lord, the order starts at page 36.
Hmm.
Heard Mr. So and so, the learned counsel for the writ petitioners, and Mr. So and so, learned standing counsel for the Education Department, Assam. This petition has been filed by the General Secretary of so and so. The prayer incorporated in the writ petition is for a direction for provincialization of the left out schools of the petitioner association situated in 8 districts in the state of Assam. The grievance is that the school in question fulfilled the requirements for the purpose of provincialization, and despite that, the respondent authority have not taken any decision in this behalf. This court, in exercise of its power under Article 226 of the Constitution, is not inclined to issue a mandamus to the respondent state for provincialization of the schools. Whether the petitioner schools fulfill the eligibility criteria is a matter which has to be inquired into by the respondent state. In view of the above, this petition is disposed of, and the respondent authority, particularly the Secretary to the Government of Assam, the Education Department, is directed to examine the matter and pass appropriate orders to examine the matter and pass appropriate orders as may be considered expedient. In the given situation for provincialization of the schools in question, the petitioner shall submit a representation to the Secretary to the Government of Assam in the Education Department along with a copy of this order. Now, my lord, this is Annexure 5.
No, Mr. Sharma,
My
you
lord.
were right, Acruz. At that point of time, that's all right. There is no dispute.
My lord.
But due to operation of law, your claim is now barred under subsection 2 to section 8. 8. So how can it be overcome now?
My lord, my lord, 8(2) states that the teachers whose services have been provincialized under this act shall get full scale of pay and such emoluments as salary and allowances as per norms of the state government. As if they are
No,
fresh.
that's all right.
Yes.
Your service has not been provincialized under this act.
Yes, ma'am.
It was under 2011 Act.
Yes, ma'am.
But you see section 24?
24.
Yes. Prior to, whose
Yes.
services were provincialized prior to 23rd of September 2016 shall continue.
Yes.
And their cases shall be reviewed as per eligibility norms set forth
Under this act,
for provincialization under this act.
my lord.
Under this act, the bar is this subsection 2
Two.
of section 8.
Yes, my lord. Now, my lord, my submission to cater to this obstacle, my lord, your lordship had lightly pointed out. Page 37, there was a direction, my lord. In a humble submission, I'll probably be repeating the same submission, my lord. In 37, page 37, there was a direction from this court, honorable court, my lord. The court had stated categorically that the court cannot issue a mandamus, primarily because whether the schools fulfill the eligibility criteria or not is to be undertaken by the state. But that was left open to the state government, and rightly so. Now, pursuant to that order, my lord, there was a step taken by the authorities at Annexure 6, which was incomplete. Now, my lord, the records appended to this writ petition indicate that had those, my lord, at that point in time, the petitioner schools fulfill the eligibility criteria. Otherwise, they would not be accorded permission and recognition prior to 1991.
No, there is no dispute
Yes, my
about
lord.
it. He
Yes,
has
my lord.
also not disputed it.
Yes, my lord. But your lordship is very correct, my lord. In fact, the efflux of time, this is the defense which the government has been taking, my lord, that efflux of time has given the benefits to the petitioner under an act which has subsequently been repealed. And thereafter, the 17th Act came into force, which stated that there was a cut-off time prior to which all those service regulations will be undertaken under the act. Now, this was something which was beyond the purview of the petitioners, my lord.
No,
The
that's all right.
The petitioners
That's
had
all right.
approached, in fact, my lord, at the time when the petitioner services were regularized in 2013, the only legal provision which allowed their provincialization was the 2011 Act.
Hmm.
Because 77 Act, 74 and 77 rules were thereafter superseded by the 2011 Act. So the petitioners had no hand in what happened and what
No,
governed
no,
the service
that's okay.
conditions.
There is no doubt about it.
Yes, my lord.
There is no doubt about
My lord, in fact, your lordship is very correct. That 8 and 24
Hmm.
would pose a legal legal
Hmm.
obstacle to
Hmm.
the backdating of my provincialization of services, my lord.
Hmm.
But the matter remains unaddressed by the state government for 22 long years, 23 long years.
Hmm.
Efflux of time cannot be taken as a ground, my lord, to deny my benefits, which were, my lord, Article 14
No, no.
as a substantive law, my lord, would
Mr.
supersede.
Sharma, you see,
My lord.
they will rely upon the same provision, no?
My lord.
So how to overcome this?
My lord, violation of Article 14, in my humble submission, my lord, as a part 3 of the Constitution, my lord, Article 14 would overcome all legal impediments that may be provided by any act, my lord. In fact, every act and every rule, it's sourced from the Constitution, my lord, and it has to satisfy the basic ambit of Article 14.
Hmm.
Now, it is not my case, my lord, that I have been treated differently from petitioners or individuals who have been provincialized under the 2017 Act.
Hmm.
It is also not my case that I have been discriminated under individuals who have been provincialized under 2011 Act.
Hmm.
My case here is that my right to equality.
No, that's all right.
My lord, that
Your
is what I'll be harping on.
equality is there,
Yes, my lord.
but
I sought my relief, my lord, from 91
hmm.
when 2011 and 17 were not enforced. I sought my relief from there. My first settlement with the state government was in the year 1999.
Hmm.
All those issues have been taken. The government did not act. Finally, there was an act which could accommodate my claim, and they took that act to accommodate my services, and which was a good measure by the state government. My lord, I'll admit to that. But the fact of the matter remains that maybe, my lord, and this is my submission, my lord, maybe due to paucity of funds, I could not be given the retrospective benefits. Now, the ground which has been taken by the state subsequently is that retrospective benefits were not permissible under the Act,
Hmm.
which is also admitted, my lord. I cannot dispute that.
Hmm.
Neither can I dispute the provisions of Rule 24 and Rule 8. I cannot do that, my lord, because the rules are clear. But I sought my recognition under the Act of 1977 or the policy of 1993.
Hmm.
The state did not carry out an action or an exercise as was contemplated by this honorable court.
Hmm.
The petitioners have been lagging for 24 long years, and I understand your lordship's query as to how to.
No, Mr. Sharma, you do some more research. You find out whether a statutory provision can be overlooked on account of this violation of your Article 14.
Article 14, my lord. My lord, my lord.
We will grant you
To,
one day time only.
my lord, I'll be grateful, my lord. I'll be grateful, my lord. I'll
You satisfy this
yes,
part?
my lord.
Heard Mr. N. Sharma, learned counsel for the petitioner. Mr. D. Talukdar, learned standing counsel for the respondent in Elementary Education Department. You for? Ibora for BTC. Mr. Soliha for? For finance. Heard in part, list the matter Friday.
My lord, as per your lordship's convenience.
Right.
Right. I'm grateful, my lord.
Monday.
I'll give it to your lordship's convenience.
Monday date.
Monday, my lord. My lord, I'll be grateful.
Anything, my lord, 25th, my lord. Monday, I will do it out of 6, my lord.
No, only he will satisfy only one point.
My lord.
Friday. I can.
Friday. Okay, Friday then.
My lord.
Only number 6 and 7 parted list.
May I please your lordship, the matter, on last occasion, this honorable court directed to BTC authority. And though the BTC has changed, they take time for, as they are not receiving the record. And may I start today as the BTC council?
More time may be given, some instructions are awaited my consent.
Here
Madam, this is of 2023 matter. So on many occasions, the case was adjourned on account of the pair being met by the respondents.
it be listed on 21st of November.
Yes, any other date, madam, we tried to read instructions.
21st.
Or 25th. 2020.
25th March.
27.
Yes, 27th.
Okay. Art Miss A. Borua, Buzur Borua, learned counsel for the petitioner. Ms. Bora for the respondent BTC. Ms. Bora submits that instructions are still awaited and press for listing the matter on another date. Where allowed, recessal list the matter on
27 November.
27.
November.
It is being clarified that no further chance will be given to the respondent authorities to argue the matter.
Keep it part.
Item 8, quadrant meter.
I start from my lord beginning again, then it will be better.
Pavel, no happens.
I take the lordship to page number 34, this is annexer 1A. The communication basing which my lord the advertisement process initiated, recruitment process initiated, my lord. Let me just read, my lord. Annexer F34. With reference to the above, I am enclosed here with a sample advertisement for filling up the back post of Chokidar in grade 4 lower primary, upper primary schools, including practicing schools. You are therefore requested to advise advertise the vacancy locally as per enclosed advertisement through the headmaster, headmistress, headpondis of the schools in which there are vacancies of Chokidar in your district, keeping in view the following guidelines. There shall be a screening committee with the DEO, chairman, headmaster, headpondit of the school, member secretary or equivalent institution, member, DI of schools, member. After interview, the screening committee will have to prepare a consolidated list. This is important. It will come later on, my lord. After interview, the screening committee will have to prepare a consolidated list in order of performance with the detailed particulars of candidates like postal address, qualification, and experience. This list will be accompanied by the statement of the candidates' applications and testimonials for submissions to Director of Elementary Education, Assam. The screening list will contain 5 times the post notified, I think, for appointment in order of. The screening committee will forward in order of preference adequate number of SC, ST, OBC persons with disabilities, sons and unmarried daughters, ex-chairman, ex-servicemen where possible. Director of Elementary Education, Assam will finalize the select list accordingly. The advertisement will be published on or before 31/12/2005, and the submissions of screening list must reach the undersigned on or before 7/1/2006. Thereafter, my lord, school-wise advertisement has been published by the concerned head teacher on receipt of the direction from the my lord district elementary education, and screening committee constituted school-wise, and the screening committee conducted interview, and thereafter a list has been prepared and submitted. Though it is submitted in the year 2006, but there was no further progress from the government level or directorate level, my lord. Some of the petitioners approached this honorable court, page 38 Annex 2, in the year 2011 through WPC 6413/2011. And this honorable court, at page 39, my lord, has disposed of in the motion stage itself. Last paragraph. In view of the above, the writ petition is disposed of at the motion stage itself with a liberty to the respondents to deal with the matter appropriately and in accordance with law as expeditiously as possible. It was remanded to the director to deal with the matter, my lord. In spite of that, my lord, there was no further progress. Another writ petition was filed by another group, my lord, in Annexure 3, page 40, where, my lord, this honorable court has given direction at page 42, and that I'm reading from the last two paragraphs. That being the position, the present writ petition is disposed of, directing the Director of Elementary Education Assam to collect all the required information in respect of all the candidates and forward the same to the Commissioner and Secretary to the Government of Assam Education Elementary Department in respect of the selected candidates within 2 weeks from the date of receipt of the certified copy of the order passed today and be produced by any of the petitioners before the director. The Commissioner and Secretary to the Government of Assam Education Elementary Department shall within 2 weeks thereafter submit the formal proposal to the Finance SIU Department, who shall within 2 weeks from the date of receipt of the formal proposal decide about the approval and communicate such decisions to the Commissioner and Secretary as well as Director. In case the approval is granted, the order of appointment shall be issued to the selected persons maintaining the seniority as well as the provisions of reservation, etc. Thereafter, my lord, it was also not processed by the department, and thereafter, my lord, district-wise cases have been filed throughout the state of Assam. Many districts have filed their cases, my lord, and this is the third round of litigation. Order starts at page 47. Okay. I'm just taking a lordship to the operative portions. Page 31. Sorry, page 59, paragraph 31. Paragraph 31. Position thus. The only course open for the court is to set aside the letter dated such and such issued by the Commissioner and Secretary Education Elementary Department and to direct the DE to examine the materials of the selection process and to pass appropriate order in respect of selection process undertaken in respect of the districts in question, either accepting or rejecting the selection process with reasons ordered accordingly. In the event of holding that the selection process is conducted in accordance with law, it will be the obligation of the DE to publish the select list, and the respondents will then take appropriate consequent steps for eventual appointment of the selected candidates. In case it is found that selection process undertaken was not in accordance with law, DE will be entitled to issue fresh advertisement for such districts. In the orders to be passed with the DE, the number of actual vacancies that existed at the time of at the relevant point of time when the selection process was undertaken in respect of the respective districts will be specifically mentioned. As the candidates are awaiting in expectations and as more than 8 years have already passed, it is directed that this exercise by the DE shall be completed by 30/9/2014 till the DE passes the orders as indicated herein above. No fresh exercise or selection of chowkidars shall be undertaken. This was the order. Thereafter, my lord, they have passed the speaking order at page 61, your lordship will find. And
Page
in
number?
page number 61,
Hmm.
annexure 5, my lord.
Hmm.
This is the speaking order pursuant to the order of this honorable court passed by the director. At page 62,
Hmm.
they have allowed in respect of all the district, but in the case of Kachar district, there are some irregularities and they have therefore rejected. At page 62, I am reading paragraph number 2. In respect of Kachar district, 3 different lists of candidates, that too only the signature of DEO Kachar were submitted by the DEO Kachar, for which the state level selection committee of this directorate rejected the said list due to violation of the guideline issued by this office letter number 7 dated such and such. Thus the screened list of candidates in Kachar district has rejected, and the committee also decided to re-advertise the vacant post of grade 4 chokidar in government of the provincialized LP and UP schools in Kachar district as per the direction of this honorable court dated 5/6/2014, passed in the lead case in WBC number such and such. This is the operative portion. This order was put to challenge in the subsequent round of litigation, annexure 6, page 63, my lord. And order at page 70, I'm reading the last paragraph, my lord. Page
Yes.
70,
Hmm.
I'm reading the last paragraph. I have heard the learned counsels for the parties and have also perused the materials on records. This court is of the considered view that the matter with regard to the recruitment of the grade 4 post in Kachar district could have been dealt with in a more pragmatic way. Parties agree that there is no dispute to the fact that candidates, including the writ petitioners, herein had responded to the individual advertisements issued by the respective schools, and they had also undergone selections, having appeared before the respective screening committees, in which the district elementary education officer was the chairman. The said district elementary education officer Kachar must not only be aware, but must be having the various select list of the candidates of respective schools. On the basis of the individual list from the respective schools, the district elementary education officer Kachar can well prepare a bona fide consolidated list of selected candidates in order of merit as against respective schools. In this connection, such and such also submits that necessary records are required to be available in the office of the district elementary education officer Kachar, and the exercise so indicated by the court can be carried out by the said authority towards appointment to grade 4 post in government and provincialized lower primary and upper primary schools in the district of Kachar. This is, in the opinion of this court, would serve the interest of the petitioners and other deserving candidates, as it is only in respect of district of Kachar that the recruitment exercise has not yet been completed. An exercise as directed to be done above be completed within a period of 4 months from today. Needless to say that the consolidated select list that is now to be prepared afresh shall be done in strict accordance with the merit of the candidates who appeared for selection before the respective screening committees of respective schools. To facilitate this exercise, the school authorities concerned shall extend full cooperation to the district elementary education officer Kachar. All the portion is disposed of. Pursuant to that, my lord, in compliance of the direction of this honorable court, the D. Assam at page number 72, annexure 7A, issued a letter. I'm reading it. With reference to the at page number 72. With reference to the subject cited above, I am directed to request you to attend before the inquiry committee on 30th October 2018 at 12 noon to be held in the office of the chamber of the undersigned to inquire the interview process of grade 4 chokidar in Kachar district in compliance of the order dated such and such, passed in such and such. You are also requested to bring all the records available in the office along with the concerned dealing assistant with the office file and with and with you, and also to instruct the headmaster, headmistress of the concerned schools to attend before the inquiry committee along with all the relevant documents, materials, including the copy of the advertisement, attendance sheet of the candidates, proceeding books, a screening list, etc., to examine whether the selection process of grade 4 chokidar of the aforesaid school of the petitioners were made in accordance with the law or not. Thereafter, my lord, you also will find annexure 7B. This is the inquiry report. As per, I'm reading, my lord. As per,
Not necessary.
as per the, my lord, conclusion, my lord, I'm reading just the conclusion. Pursuant to that, my lord, that the inquiry has been conducted, all the candidates, including the headmasters and all officers were present before the, my lord, office of the DE Assam, before the inquiry committee. And my lord, the findings, you also will find at page number 74. After verification, findings, page number 74 in the last part. After verification of the documents and the reports as mentioned above, it is found that 50 numbers of candidates may be selected for posting in the grade 4 post chokidar of schools of Kachar district as follows. These are the names recommended by the selection screening committee, and the conclusion comes at page number 75, my lord. From the above findings, the inquiry committee has come to the conclusion that the 50 candidates for the post of grade 4 chokidar where there is no conflict may perhaps be selected for appointment. Thereafter, the selection committee considers the meeting at annexure 8A, page 76, my lord. And the selection committee has, my lord, selected. Paragraph 3. After threadbare discussion, the state level selection committee of the directorate has decided to select the following candidates for appointment to the post of grade 4 chokidar in compliance of the Honorable Guwahati High Court in order number date is answer. This is the select list, and thereafter this speaking order has been passed, my lord. In the order, my lord, it is clearly stated, page number 78. After verification of the documents and the reports as mentioned above, it is found that 50 numbers of candidates may be selected for posting in the post of grade 4 chokidar of schools under Kachar district. This is the order, ultimate order passed by the DE Assam. In spite of that, the process was hanging, my lord. Thereafter, the petitioners have approached this honorable court in page number 80 and annexure 9, my lord. They throw another writ petition. And this honorable court, my lord, you also will find at page number 88. Order starts, page number 89, my lord. I just read the paragraph 5. This court, after having perused the order dated and such, is of the view that the concerned authorities have verified the matter regarding the selection of candidates for appointment to the post of grade 4 in various schools in Kachar district, and accordingly, the said order dated and such was issued by publishing the select list consisting 50 candidates in respect of Kachar district. Under such circumstances, there should not be any difficulty on the part of the state authorities to act upon the same and issue necessary appointment orders. Accordingly, the respondent authorities, more particularly the respondent number 1, is directed to consider the said select list published by the director, and if the same is approved, the necessary appointment orders may be issued by the appointing authorities, that is Director of Elementary Education Assam. This is the order passed by this honorable court. My lord, you will find there was an interdepartmental correspondence from the director office to, my lord, the government, my lord.
Thereafter, what happened?
My lord, in the departmental correspondences, my lord, they have clearly stated at page number 90, annexure 10A, you also will find, last paragraph I'm just reading. Under the facts and it is written by the director to the government, my lord. Under the facts and circumstances stated above, the government is therefore requested kindly to accord necessary approval for issuing appointment orders to the selected candidates of the Kachar district along with SIU approval to the post of grade 4 of LP and UP schools for compliance of the order of the Honorable Guwahati High Court. This was the my lord, correspondence issued by the director to the commissioner. And there are other correspondences, my lord, you also will find one after another correspondence is there. And ultimately, my lord,
what is the stand of the department?
Malad, the page 101, Malad, is an order, Malad, passed pursuant to the order that was the direction of this honorable court at page 88. Page 88, Malad. The page 101 is the order, Malad, where it has been passed. Finance has rejected to accord approval for appointment of the appointment orders, Malad. Thereafter, Malad, they initiated a contempt proceeding, Malad, which
No,
was
why,
by this honorable court saying.
No, why the finances refused to accord approval?
The finance took into consideration their office memorandum of 2012, which says, well, before any selection is to be conducted, well, the approval has to be taken from the finance. Well.
No, in respect of other districts, all the candidates have been appointed?
SIO approval was taken.
In the other district, it was taken, Lordship. There was some anomalies in only Pachar district, because of which the other, they missed all the formalities. Lordship. In respect of Pachar district, there was no SIO approval was taken. That is one distinction, between Pachar district and the other districts. Lordship.
Okay.
In fact, my lord, in respect of the Kasar district, my lord, even the earlier speaking order, which has been rejected, my lord, there was one indication that the select list which has been prepared by the Kasar district, my lord. Rest of the other district, the select list were proper. My lord, it was countersigned by all the committee members. Now, if your lordship will kindly see the guidelines, my lord, that was based on which this advertisement was issued. Page 35, my lord, kindly, by page 34, my lord, kindly. There is a composition of the screening committee, my lord, who will conduct the interview, my lord. Page 34, clause 1, my lord. There will be a screening committee with the DEO as the chairman, headmaster, head pandit of the school member as the member secretary or equivalent institution member, and DI of the school member, my lord. This is the composition of the committee, my lord. Now, my lord, earlier, my lord, my friend referred to page 41, page 42 order, the direction. Page 42, my lord.
Yes.
Malad, this is the repetition of Hailakandi district, my lord, where the facts were different. Page 42, in fact, my lord will see the in the top, my lord, the paragraph starts from it appears that the preparation and publication of the select list on 27/7/2010 pursuant to the selection process initiated is not in dispute, my lord. In that case, there was already a select list which was published. Now, the repetition which this petitioner preferred, page 39, my lord. Third paragraph. While the learned counsel for the petitioner has emphasized on early publication of the select list and appointment. In respect of the petitioner, my lord, there was no select list published. This, my lord, will kindly see again the series of repetition which was filed by the common judgment has been given. But even in that judgment, page 59, my lord, kindly. Paragraph 31 was read, my lord. I'll read paragraph 31. This honorable court did not upheld the selection process, my lord. On the contrary, my lord, what has been said, my lord, to see. The author of the letter dated 19/11/2012 may be a superior authority to the DE. Paragraph 4 of the affidavit of the DE shows that the DE has not even examined and evaluated the selection process. Though he is the person who is to publish the select list. No records have been produced before the court either. Materials on record do not disclose that some selection process was undertaken. And to that effect, the first sentence of the letter dated 19/11/2012, there was no evidence whether any selection was conducted is apparently wrong. It is another matter whether the selection process can withstand the scrutiny of law. So this honorable court, my lord, while dealing with that issue, interfered with this letter of 1912, 2011, 2012. Only on the basis, my lord, because there was no materials placed on record that the selection was wrong. And accordingly, my lord, this honorable court has directed at page paragraph 31. My lord, may I just raise one word, your lordship will mark. Position does the only course of open for the court is to set aside the letter dated 19/11/2012 12 issued by the Commissioner and Secretary and to direct the DE to examine the materials of the selection process and to pass appropriate order in respect of the selection process undertaken in respect of the districts in question, either accepting or rejecting the selection process with reasons. Order accordingly in the event, my lord, you can mark this one. In the event of holding that the selection process is concluded in accordance with law, it will be the obligation of the DE to publish the select list and the respondent will then take appropriate consequential steps for eventual appointment of the selected candidates. In case it is found that the selection process undertaken was not in accordance with law, he will be entitled to issue a press advertisement for such districts. So, my lord, none of the orders, my lord, where there was no finding with regard to that the selection process was conducted properly, my lord. Now, this speaking order, my lord, page 62, just down below the table, my lord, will find. In respect of Kasar, my lord, these petitioners are from Kasar district. In respect of Kasar, 3 different lists of candidates that took only the signature of the DO were submitted by the DO Kasar, for which the state level selection committee of this directorate rejected the said list due to the violation of the guideline issued by this letter dated so and so. And thus this clean list of the candidates in Kasar district has rejected, and committee also decided to re-advertise the vacant post of grade 4 as per the direction of the honorable court and passed in the lead case in WPC number so and so. Now, my lord, thereafter this was put to challenge, though this honorable court has interfered with this speaking order. If your lordship will kindly see, after the finance has rejected to grant approval, my lord, on 18/12/2000, page 101, 18/12/2023. This is the subject matter of challenge in this repetition.
Page number?
Is 101.
Hmm.
This is what has been challenged in this repetition.
Hmm.
May I just read this?
Mhm.
All reference to the subject cited above, I am directed to inform you that as part of his memorandum that it was clearly mentioned that all administrative department will continue to move finance SIU department for their prior approval as per existing procedure, and no grade 4 post or post of teachers, elementary schools and drivers shall be filled up by any appointing authority without prior approval of the finance department. The finance SIU department has informed that any appointment that has to be made in any government by the government has to be in accordance with the service rules as existed at the time of initial appointment process. As per your report later dated so and so, it has emerged that there was already an existing guideline issued by letter dated 16/12/2005, and the selection committee of the directorate had rejected the 3 numbers of different list of candidates submitted by the DO due to the violation of the said guideline. In the light of the above facts and circumstances, existing guideline laid down by the finance SIU department, this department is not in a position to accord approval for the appointment orders of the select list published by the DE, which at the time of the advertisement was neither approved by the department nor was the necessary concurrence of finance or paid for filling of the vacant post. Under Kasar district, you are requested to take necessary steps as per the order of the Honorable High Court, so and so accordingly. Pursuant to this, when this communication has been challenged in this repetition order, the government consciously, has constituted another committee to inquire into the entire. Your lordship will find the report of the inquiry committee.
Page 125.
Page 125, and the composition of the committee, my lord, will find page 17. Page 172, my lord, you can. This is a 3-member inquiry committee appointed by the government, to inquire into the entire case of this petitioner. Now, page 125 is the inquiry report, where the
Page number
125.
Yes.
First paragraph I'll read now. The inquiry committee was constituted by the government by letter dated 2nd of March 2024 with the objective to inquire and ascertain the circumstances that led to the appointment of grade 4 Chokidar post in 16 district of the state against the advertisement in 2005. The three-member committee accordingly sat several times with the files submitted by the convener from the Office of the Director of Elementary Education staff and tried to look into the whole issue throughout to all the records available in these files. Now, my lord will kindly see, come to the findings of at page 128. A case is being projected in the repetition that the other, in respect of the other candidates in the other district, though the approval was not given and therefore though the approval was not there, but they have been appointed. Now, your lordship will kindly see the finding of the page 128. All districts constituted the screening committee as stipulated by the Director of Elementary Education, which then published the advertisement and the interview. All the districts then submitted the select list of the candidates by putting signature of all the members of the screening committee. That is the headmistress, head pundits, as the member secretary, the deputy inspector of school as the member, and the DO as the chairman while preparing the school-wise and consolidated list. Well, this is in consonance with the guidelines that under which the advertisement has been issued. Page 34. On the other hand, Kasar district had submitted their list only under the signature of the DO, both in the school-wise as well as the consolidated list, which bespeaks of malified intention and manipulation. Hence, it is also doubtful whether the screening committee has been constituted at all in the Kasar district. This is also observed that the other districts has prepared and submitted the single consolidated list in conformity with the guidelines issued by the then Director of Elementary Education, Assam. Whereas Kasar district has submitted multiple lists. My lord, kindly mark this. Has submitted multiple lists time to time without any signature of other committee members, but only under the signature of the DO, which was a clear violation of the guideline issued by the Director of Elementary Education, Assam, for appointment to the post of grade 4. The Honorable High Court, by the order dated so and observed that the recruitment of the grade 4 post in Kasar district could have been dealt in a more pragmatic way. In that view, the Honorable Court directed the DO Kasar to prepare a bona fide consolidated list on the basis of the individual list from the respective schools and in order of merit in the respective schools. But the same exercise was never undertaken by the DO Kasar. The DO neither examined, compared the school-wise list prepared earlier, nor even prepared a bona fide consolidated list. Instead, the DO had submitted the earlier list prepared in 2011 when he was called to appear before the inquiry committee constituted by the Director of Elementary Education, Assam in 2018. This is this inquiry report, annexing the repetition which has been referred by my friend. The direction contained in the judgment order dated 12/7/2018 in WBC number so and so has never been carried out in the letter and speed. Though in 2018, the DE Assam has constituted an inquiry committee and accordingly inquired into the matter to dispose the issue, but the committee prepared a list of 50 candidates on the basis of the list submitted by the DO, which were not signed by other members of the screening committee. Hence, the list prepared by the inquiry committee constituted by the Director of Elementary Education, Assam, also could not ascertain as a bona fide list, as no pragmatic exercise was ever undertaken neither by the DO nor by the director in the process of preparing the list. Concluding remark. As evident from the aforesaid fact, the appointment to the post of grade 4 in all respect of all other districts, excluding the Kasar, kept on going since no such anomalies in the list submitted from the concerned screening committee were ever detected in any level. On the other hand, the finance SIU approval was taken in respect of each and every appointment of all the other districts before the appointment letter. In case of Kasar, although the list of 50 candidates finally selected by the inquiry committee of directorate level and later endorsed by the SLC is edified on which the present claims for appointment are going on. Yet the list itself was prepared based on the list signed by the EO, which clearly smacks of manipulation and malified intention. At no level any attempt was ever made to do away with these issues or deal with the issues in more pragmatic manner as directed by the Honorable High Court in judgment and order dated 12/7/2018 in WBC number 6766/2016. In view of the above finding and additional facts that have emerged from the inquiry, the government seems to be right when it expresses its inability to approve the list of 50 candidates in case of Kasar with communication dated 18/12/2020. So, look, Apparently, well, the list based on which they are claiming to be appointed, well, that list is in violation of the guidelines, well, under which the advertisement has been issued.
No, which provisions provides for obtaining SIU approval before issuance of advertisement?
Yes.
Where it is provided?
It is there, well, in the concluding note, page 129.
One?
The report of the inquiry committee.
No. Before beginning your argument, you have submitted that.
No, Malad, the 1812 order, 1812 communication method, which was issued by the secretary to the elementary, which is a subject matter of challenge in this repetition. It refers to an office memorandum of the finance department of 33/2012. This is an internal communication method where the rejection of the finance department has been communicated to the director. It's a communication method between the government and the director.
No, that's all right. Here there is a reference to the OM
OM.
of the finance department. Where is that OM?
Page 190.
190. Which is the relevant clause?
Clause 7 was it?
Clause 7.
Where it stated the existing procedure will continue for filling out of vacant grade 4 posts of all designation description as well as posts of drivers and teachers of elementary school, that is teachers under elementary education. Until further orders, all administrative departments will continue to move finance SIU department for prior approval as per existing procedure, and no grade 4 posts or posts of teachers of elementary schools and drivers shall be filled up by any appointed other than without prior approval of the finance department.
Is OM is updated 2012, and when the advertisement was published?
Advertisement was
2005.
5.
Yes, but the selection process was going on at that time of, I think, finalization was done after this poem.
Even the order of this honorable court at page 47 is after
No.
2014. Is of
If
2014.
the process is initiated in the year 2005, by publishing this OM in the year 2012, can you give its a retrospective effect from the day from 2005? Maybe.
And this was.
No. The principle is that when the game is started, you cannot change the rule of the game.
Yes, Lordship, that there was a education department memorandum also, Lordship, which was where the procedure was laid down and it was not followed. That Lordship, regarding
So that OM.
Lordship, that will be by Lordship here, as per this OM, the other districts did take.
No, other district have obtained their approval, that's all right.
Yes.
But the question is, can you give a retrospective effect of this OM with effect from 2005?
Well, there are two reasons for the finance to reject it, madam. It is 101, my lord, see third paragraph, madam.
Yes.
Finance SIU department has informed that any appointment that has to be made by the government has to be in accordance with the service rules as existed at the time of the initial appointment process. This is the one ground of rejection. As per your report dated so and so, it has emerged that there was already an existing guideline issued by letter dated 16/12/2005 and the selection committee of the directorate had rejected the 3 numbers of different list of the candidates submitted by the DO due to violation of the said guidelines.
Where is that guideline?
Page 34 million.
Where it is provided that they have to obtain approval from the
No,
finance
not
department?
approval. It doesn't speak about approval.
Violation.
This page 101, that paragraph which I have read, my lord, it says the finance department has informed that any appointment that has to be made by the government has to be made. Just read it. I'm reading it again. 101. Finance SIU department has informed court, my lord, within the court, any appointment that has to be made by the government has to be in accordance with the service rules as existed at the time of the initial appointment.
Yes.
Yes.
Oh.
And the service rule that, my lord, the guidelines is page 34.
Mm.
16/12/2000.
That there is the committee, there will be a screening committee consisting of these 3 members.
No. What is provided in the rules? Service rule.
But at that point of time, there was no service rule in respect of appointment of the grade 4 member. And therefore, this is the,
There was an existing
there-
guideline.
this is the guidelines of 16 December 2005 my lord,
Mm.
by the director. my lord.
Mm.
There-
To
But
all district officials-
here there is, it is not provided that approval from the finance department has to be obtained.
That's not.
But it was provided that there will be a screening committee consisting of all the members of it. And the members is DEO, headmaster.
And it is undisputed, my lord, the 3 lists that is prepared by the Kasar, my lord, none of the lists, my lord, contain the signature of the members,
All the members.
all the members. In fact, if your lordship will see, this honorable court, my lord, the inquiry report which they are relying and the select list which they are saying that this is the select list
Mm.
based on the inquiry that was done pursuant to the order of this honorable court in WBC number 7663.
Mm.
Now, this honorable court, my lord, in fact, in any of the litigation, my lord, this honorable court has never concluded that the selection has been done in a, on the contrary, it has been said, my lord, as the selection has begun, it should be completed. The direction was only to that extent. In fact, 7663
Mm.
repetition, my lord, the order, my lord, will kindly see.
No, that's all right.
Yeah.
That direction is there.
In fact, that direction was to prepare a consolidated
So,
list in a pragmatic manner.
In the present petition, your stand is that at the time of advertisement, they have not obtained approval from the finance SIU department. That is one. And number 2, the select list does not contain the signatures of all the members of
The
the
select list is not a valid select list in terms of the guidelines under which the advertisement. has been issued.
2005.
Yes, under which the advertisement is issued.
Hmm.
And this inquiry report, well, which we have annexed in the petition,
Hmm.
it is not under challenge. The findings of the inquiry report is not under challenge.
Hmm. Yes, Mr.
One more, my lord, thing, my lord, I'd like to point out, my lord. If your lordship will kindly see the prayer in the repetition, my lord, is 13.
Yes.
First is, my lord, to set aside and quest that 18/12/2023 communication. That communication, my lord. And direction to the respondent to issue appointment orders, my lord, in favor of the selected candidate.
Communication
including
means
the
there's a
minister.
page number 101.
My lord.
Page number 101.
Setting aside page number 101
Hmm.
and direction to issue appointment orders as per the select list and recommendation of the state level selection committee 7/3/2019
Hmm.
in compliance of common order dated 12/7/2018 passed by this court in 7/663/2016.
Hmm.
Now this by subsequent inquiry report, that inquiry report has already been held to be said to be bad, Miller, saying that though the Honorable Court has directed to adopt a pragmatic way to prepare a consolidated report, but that inquiry committee has taken into consideration that invalid list only and had prepared the select list. So this select list cannot be said to be a valid select list, my lord, for which, in my respectful submission, my lord, there cannot be any appointment.
Whether that list contains the signatures of all the members.
But that, my lord, kindly allow me. Page 129, my lord. Page 129. The subsequent inquiry report has taken note of the Honorable Court direction.
Hmm.
Page 129. Serial number 3
Hmm.
from top. Honorable High Court by its order dated 12/7/2018, WPC number 766/2016 observed that the recruitment to the grade 4 post in Kasar district could have been dealt in more pragmatic way. In that view, the Honorable Court directed the DO Kasar to prepare a bona fide and consolidated list on the basis of the individual list from the respective schools and in order of merit as against the respective school. But the said exercise was never undertaken by the DO Kasar. DO neither examined, compared the school-wise list prepared earlier, nor even prepared a bona fide consolidated list. Instead, the DO had submitted the earlier list prepared in 2011 when he was called to appear before the inquiry committee constituted by the Director of Elementary Education, Assam, in 2018. Thus, the direction contained in the judgment and order dated so and so has never been carried out in letter and spirit. Though in 2018, the DE Assam has constituted an inquiry committee and accordingly inquired into matter to dispose the issue, but the committee prepared a list of 50 candidates on the basis of the list submitted by the DO, which were not signed by the other members of the screening committee. Hence, the list prepared by the inquiry committee constituted by the Director of Elementary Education, Assam, also could not be ascertained as a bona fide list. So now, well, he is asking for appointment under this list.
Hmm.
As no pragmatic exercise was undertaken by neither by the DO nor by the director in the process of preparing the list.
Yes, Mr. Urkesto, how do
Yes.
you address the issue that
Yes,
the
yes, sir.
selection list does not contain the signatures of all the members
Yes,
pursuant to the guidelines of
I will give reply to my learned
2005?
friends, sir, for this matter.
Okay, I will resume after 5 minutes.
Yes. God bless. আৰু কিবা ক'ব থাকিলে কৈ দিয়া গোটেইখিনি
Yes, regarding,
Judgment.
no, regarding,
Regarding now, even assuming the lordship holds that this 15/12/2023 communication informs about the reason for rejection of the SIU approval.
Hmm.
Even if it is interpreted with the other prayer methods where they have prayed for issuing an appointment order on the basis of the select list, which subsequently in an inquiry has helped me an select list, invalid select list.
Hmm.
So can there be an mandamus to that effect?
Hmm.
Because first is 2003-11 SSC 766,
Hmm.
paragraph 12 actually.
2000,
2003-11 SSC 716.
paragraph,
Union of India versus Tarun Kumar Singh. Paragraph 4.
yes,
The question for consideration is whether the knowledge legal judge of the Allahabad High Court was justified in interfering with an order of cancellation passed by the competent authority and directing that the process of selection should be completed. Needless to mention that the subsequent order of cancellation, in view of the allegation and malpractice and the departmental authorities has held an inquiry into the matter. The result of the inquiry revealed gross irregularities and illegalities as referred to in the judgment of the division bench of the Allahabad High Court. Consequently, the process of selection to a public office stands vitiated by adoption of a large-scale malpractice cannot be permitted to be sustained by a court of law. That effort an individual applicant for any particular post does not get a right to be enforced by a mandamus unless and until he is selected in a process of selection and gets letter of appointment. In the case at hand before March, before the so-called list selection was approved by the authority, the order of cancellation had emanated on the process basis of the complaint received from many quarters. But I'm trying to impress upon Madhav,
Is there any complaint in this process?
No complaint.
Is there any complaint in this
In
process?
this case, it was not. There was no complaint.
Hmm.
But
Then
while in the
is
process
there,
of an
no,
inquiry-
Mr. Kosik, you say, is there any allegation regarding malpractices here? No.
That is what the inquiry report, the subsequent inquiry has categorically said that there is anomaly in the selection process, and if your lordship will see the exact words they have used in the inquiry,
Hmm.
and this inquiry is not under challenge.
Page number?
The page 128 finding. Page 128,
Yes.
the last portion of finding one.
Hmm.
On the other hand, CASA district has submitted their list only under the signature of PEO, both in school-wise as well as consideration list, which bespeaks of malafide intention and manipulation.
Hmm.
Hence, it is also doubtful whether the steering committee has been constituted at all in the CASA district. There is a categorical finding of anomalies in this case.
Hmm.
And more so, that the select list is not in consonance with the guidelines under which the advertisement has been issued. And this inquiry, my lord, will kindly note, my lord, it is not challenged. This finding stands, my lord.
Hmm.
My lord, one judgment of our High Court, my lord, in that case, my lord, what happened, my lord, after the selection was initiated, my lord,
Hmm.
for the judgment of our High Court in Montu Deka's case. But in this case, my lord,
Hmm.
it was also in respect of grade 3 and grade 4 appointment because
Hmm.
selection process was initiated. Thereafter, in the process, my lord, we cancelled the selection process. Saying that there has been anomalies in the selection process. The
Hmm.
challenge in this retribution was, my lord, that there was no inquiry. No inquiry was made, and therefore that cancellation is wrong. My lord. This honorable court has upheld the cancellation by reiterating the principle of law, that is, my lord will find page 35, paragraph 22, 23, and 24.
Hmm.
In this context, to scrutinize the legality and the validity of such a decision to cancel a selection process, this court must also take note and consider the right of the candidates to have the selection concluded. It is by now well settled that an advertisement inviting application for appointment to conduct vacant post at a particular department does not create any legal or fundamental right in favor of the participating candidate to get a selection completed, and therefore the writ of mandamus to that effect cannot be issued in as much as for issuance of writ of mandamus, the existence of a right and violation thereof at the hand of the state and or a corresponding duty upon the state is a sine qua non. Further concerning the selection and recruitment process, it is equally well settled that merely participating in a recruitment process or sitting in examination of
No, that is
Therefore, my lord, as on today, my lord, they will have to establish that the select list,
Hmm.
which based on which they are asking for an appointment,
Hmm.
is a select list is valid in the eye of law.
Hmm. Okay.
May I please?
Yes.
My learned friend has referred to judgment of 2010 and judgment of 2011. I have
Mhm.
annexed
Hmm.
that with regard to Hailakandi district and one is with regard to Malur Kachar district. Answer, my lord, the process of publication of selection started only after the judgment, common judgment passed by this honorable court, not prior to that. This is the answer of his first query, my lord.
Pardon?
The process of selection process at the
Hmm.
directorate level
Hmm.
in respect of all the districts have started only after the judgment dated, my lord, 15/6/2014.
Page
40
number?
Page 47. This is the common judgment. Before that, for last 9 years, there was no further process. Page 47.
Hmm. Yes.
This is the order. After this order, the process started, and that too started after passing of the speaking order dated 22 December 2014, page 62. Before that, no selection list was published. In
Page
respect
number?
of
Page number?
page number 62.
Yes.
22 December 2014. Only after that, this started. Second query, my learned friend raised, my lord. With regard to, he has expressed his doubt with regard to conducting of the screening at the district level, etc., my lord.
Mm.
This honorable court, while passing the order dated 12/7/2018, they have contested in this case the department, and after taking into consideration all the materials put by them, this honorable court has passed the order at page 69, my lord. Admitted in the page number 70, last paragraph.
Hmm.
Parties agree and that there is no dispute to the fact that that candidates, including the writ petitioners herein, had responded to the individual advertisements issued by the respective schools, and they had also undergone selection, having appeared before the respective screening committees. This is the findings of this honorable court.
No, that's all right, but why accept the signature of the district elementary education officer? The members of the selection committees are not there in the list prepared for the
Yes,
Kasar district.
that I must say. That's because this honorable court, this was the ground for rejection for passing the speaking order, which was put to challenge in this case, and therefore this honorable court has directed that the director of elementary education office, elementary education, shall again redo the exercise, and therefore at page number 72,
No,
this
okay, it was redone, but on the basis of the said select list, three
Yes.
select list.
yes, on the basis of
prepared
that,
earlier.
selected those who, this is not the fresh candidates will be invited, not that the fresh post will be included. It is the same candidates, same head, same schools.
No, those three lists also does not bears the signatures of the other members of the selection committee.
No. The select list initially submitted, that is only produced by the DEO Assam. That is and as per their select list, those head teachers of those schools and the member secretaries of those schools have been called for and appeared before the inquiry committee, and they have put their signatures, and that is why this list is published by the DEO Assam. That is the reason, as there was no signature in the list forwarded by the DEO Assam, DEO Kachar. Therefore, my lord, this inquiry conducted to take the to remove the anomalies. That is the reason they have, my lord, conducted the inquiry, and your lordship will find at page 72, they have called for all the headmisters, head teachers of the concerned school to be present in the inquiry. Accordingly, all appeared and this inquiry took place. And they have on that day, school-wise, the documents have been produced before the inquiry committee, and on the basis of that, they have, my lord, prepared this. They have said I have annexed some weak, my lord, as per the guideline, page 34, all the documents are not required to be submitted before the DE Assam. Only the screening list showing the names of the candidates' address has to be submitted. Page 34. Clause 2. After interview, the screening committee will have to prepare a consolidated list in order of preference with these detailed particulars of candidates like postal address, qualification, and experience. These three things has to be included, and this list has to be submitted. And official being the DO being the head of the office, he has signed and forwarded it. But what they want to mean, my lord, this tabulation that is prepared at the time of interview, in that tabulation, all the members have put their signatures, and on the basis of those tabulations, the consolidated statement is list is prepared and that is submitted.
Where is those list?
As an individual, they have suppressed, they have hidden all these documents from the office, my lord, but we could produce one through additional affidavit. We could produce, they have, my lord, page number, for example, only to show the example, we have just could produce, my lord, in an additional affidavit filed by us, additional affidavit, my lord, page number 204, I think. With that, only to just show the example. Page number 213, you also will find. Somehow we could produce from one of the head teacher, my lord. 1, 2 of the head teachers they gave us. Page number 225. Some with regard to some of the schools, so in every school that is there, that is done. And with regard
This is in respect of individual school,
individual schools,
but
in-
in respect of the entire district, where is the?
entire district, only the district elementary education officer has forwarded, because
But,
they
whether it is provided in the guideline. Annexer 1A, page number 34,
consolidated lead has to be forwarded, my lord.
then
It is not also stated, but it should be signed by all.
yes, Mr. Kosik, where it is provided,
Page 34, my lord, that's similar.
clause number.
Clause 1 is the screening committee, my lord.
Uh,
Clause 2, after the interview, this screening committee will have to prepare a consolidated list. It is the screening committee entirely, my lord. Cannot be, my lord, the one member of the screening committee will prepare the consolidated list. One says about who would be the screening committee, and 2, my lord, page 34, my lord. Page 34, 2 says, after the interview, the screening committee will have to prepare a consolidated list. It doesn't say, my lord, only the chairman of the screening committee will prepare the consolidated. But it is otherwise, it is a normal practice, my lord. When a committee approves the list, my lord, prepares the list, every committee member signs it. Likewise, my lord, if a committee holds a meeting, my lord, the minutes has to be signed by all the members. Unless it is signed by all the members, it cannot be taken to be a decision taken by the committee. And only in Kasar, my lord, it is an exception, my lord. But
Mm.
in rest of the 16 districts, everybody has followed the same practice, my lord, same procedure. As it has been laid down in the 16 December 2005, my lord, the guidelines.
This is not correct, my lord.
And what my learned friend is saying, my lord, that it is correct, my lord. The select list was prepared only after 2014. So before the 2000, before the select list was prepared and approved, my lord, this office memorandum of finance department came into force, my lord. So before the approval, SIU approval was taken by the authorities, my lord, in respect of the select list.
Let me answer, my lord, one after another. Thereafter, my lord, my lord, with regard to Tinsukia district, I have annexed the additional affidavit, page number 236. It is the consolidated list, my lord, signed by the district elimination officer Tinsukia, single signature, and this is acted upon. This was the part of the earlier round of litigation where I was the counsel, my lord. I could proceed from there. Page number annexure 50, page number 236. This list is acted upon already. देखा हम क्या नहीं देखा This is one aspect. With regard to SIU, my lord, I give the answer, my lord. I take your lordship to page number 113. On 3. Annexure 13A to, my lord, 13D. Your lordship will find the finance department has been moved in the year, my lord, 2015, and page number 114, it was approval dated 12 October 2020. SIU approval was granted in the year 2020.
In respect of?
In respect of 57 numbers of sanctioned vacant post, in connection with other cases, some petitioners are there in respect of those, my lord, those districts. And page number 115. It was in the year 2021. And 116, my lord, is also in respect of another 50 numbers of. And last, my lord, in the year 2023, last page, 117, 18 to 2023, in respect of 5 numbers of candidates. It is not the fact that, my lord, it is a requirement, but it is it can be taken, approval can be taken at any point of time. It cannot be ground that as in the year 2005, the approval was not taken. Memorandum has come in the year 2012. And therefore, all the appointments in respect of all the districts have been made by taking the approval subsequently.
In respect of the 57 candidates,
Yes,
approval from the SIU department was taken in the year 2020,
yes,
as per this letter,
yes,
annexure 101.
yes, Lordship.
Yes, Mr. Saliha,
Yes.
page number 114.
Yes, Lordship, here, as from the record, we can find out, Lordship, who And this has been done in accordance with the OM of 2012, Lordship. There it has existed. Now, Lordship, in this case, Lordship, their approval is not given, Lordship, because their entire list is in doubt. Now, if from the.
No, no. Have you gone through this letter? Page number 114.
Yes, but these are regarding the other districts, Lordship. And there is no dispute regarding the select list, Lordship. Only in the district of Kasar. Yes, yes, yes. But we have given. Lordship, here, there, in these cases, the list has not been disputed, Lordship. This has been forwarded. Here, there is an inquiry report against Kasar district where the entire list is being disputed. Now, Lordship, here, as the officers of the court, and there is a state, this is the public money, Lordship. When there is a disputed question of select list, Lordship. And where we have to go strictly according to the law. Lordship. Here, where there is a dispute arises, Lordship, can there be a mandamus where my learned friend, without going through a re-verification process, can they be given approval, Lordship?
No, Mr. Phuket, so this page number 114 is in respect of which district?
My lord,
It is not mentioned in.
not mentioned here, my lord. But in respect of so far as I remember, it might be in the Kamrup district.
Kamrup.
I remember. Because Kamrup, Hailakandi and some other cases, some other districts have been given. Last
But in respect of Kasar district.
proposal have been submitted, but they
Where?
have rejected on this ground that in the year before advertisement it was not taken.
When it was rejected.
So the impugned, my lord, or communication order, my lord, page 100. So. So, my lord, my learned friend has raised the inquiry report. This is manufactured document after filing of this case. They have constituted the committee. They have concluded their part. Through this impugned order, entire process has come to logical end in the departmental level. Thereafter, we have come to this honorable court. What authority they have got, my lord, to run independent proceedings with them? And that too not as per the direction of this honorable court. This honorable court has given the direction for redoing the exercise in a pragmatic way, not for redoing the inquiry in a pragmatic way to cancel the exercise done by the director. And that too after concluding. Why shall I challenge, my lord? This is not a requirement. They have no authority to do this. Once the matter comes to an end, that is the end of the matter. They cannot create fresh cause of action by arbitrarily exercising their administrative power.
So this inquiry was conducted as per order dated.
The department has conducted inquiry, my lord, as per the order of this honorable court dated, my lord.
No, this subsequent inquiry report, annexure B of their.
After filing of this honorable, after filing of this case, my lord.
When this case was filed.
This was filed, my lord. It is
24.
yes, lordship.
But when this inquiry was conducted.
Yes. After filing of this case, it is 5th January 2023. The affidavit, my lord, sworn.
So this inquiry has been constituted, Mela, when this controversy was raised in this repetition, that for the other district, the same.
But there is no direction of the court to constitute such.
There is no character. In fact, Mela, the first paragraph of the inquiry report, Mela, the constitution of the inquiry committee, page 172, my lord. In the interest of public service, the governor of Assam is pleased to constitute a 3-member inquiry committee
Mm.
to look into and ascertain the facts and circumstances that led to an appointment of grade 4 chowkidar post in 16 districts of the state.
Mm. Page number?
Page 172. The notification constituting the inquiry by the governor of.
But when the matter is pending before this court, whether this exercise can be carried
Yes,
out
well,
without the leave of the court.
Yes, my lord, because what they are challenging this repetition is 18/12/2024 orders, the communication order. And then other prayer which they have made is to appoint them on the basis of the select list that was prepared by the DEO, the Director of Elementary Education. Now to ascertain whether that select list is possible is correct or not, this inquiry is constituted. And in my respectful submission, my lord, as the matter is pending, my lord, the decision with regard to the inquiry report has not been taken by the government. Though the inquiry report has submitted, but the government has not taken any decision on that inquiry. It's yet to take decision on this inquiry. But as the matter is pending, it has brought to the notice of this court, my lord, that in the inquiry it is found that the select list on the basis of which he is asking for an appointment, that select list is not a bona fide select list. And that select list, because this honorable court directed to prepare a bona fide list, my lord, this WPC 7663 would say that the Kachar could have, the district of Kachar could have adopted a pragmatic way and to prepare a bona fide consolidated list.
No, that's all right, but that list was prepared in the office of the directorate.
Yes.
And that list has been examined by this inquiry committee. Whether that list has been properly prepared or not. In fact, the inquiry committee came to a finding that the director, while preparing the list, took into consideration that same old earlier list without signature. No fresh exercise was undertaken as per the direction of this honorable court.
No. Whether there was a direction for doing fresh exercise.
Yes, madam. Yes. The order in 7663, my lord.
Page number?
Is 69 order. 12/7/2018. Is 70. I have heard the learned counsel for the person and I have also perused the materials on record. This court is of the considered view, the matter with regard to recruitment to the post of grade 4 could have been dealt with in more pragmatic way. Parties agree that there is no dispute. The fact that including the prisoners herein had responded to the individual advertisement, they had also undergone selection, having appeared before the respective screening committee, in which the district elementary education Asar was chairman. The district elementary education officer must not only be aware but must be having various select lists of candidates of respective schools. On the basis of the individual list from respective schools, the district elementary education Assam can well prepare a bona fide consolidated list of selected candidates in order of merit and against the respective schools. Now, the direction below. An exercise as directed to be done above be completed within a period of 4 months. Needless to say that the consolidated select list that is now to be prepared afresh shall be done in strict accordance with the merit of the candidates who appear for the selection before the respective screening committee of the
No.
respective.
how this exercise has to be done is set out in the earlier paragraph. That is on
Yes.
the basis of the individual list
In the basis of the individual list, a
from
consolidated
the
list is
list
required to
from
be-
the respective schools.
Yes, it is
And
required.
you see, the director, deputy director, after hearing the headmasters of the schools and conducting inquiry has
Well,
prepared
yeah.
that list.
My lord, with most respect, my lord, the inquiry report, the lordship will see, there is not even a single whisper, my lord, how this select list is prepared. It is only that select list which was earlier sent by the DE.
Mm.
DEO earlier in 2000,
Mm.
in the first select list that was submitted by the DEO, without that is prepared by him alone, my lord.
Mm.
That list is the basis of preparing this list, my lord, by the director. And the subsequent inquiry that was constituted by the government, my lord, that in 3-member committee has observed that the director has taken neither the DEO has undertaken any fresh exercise as directed
No,
by
no,
the board.
that inquiry report cannot be acted upon for the simple reason that it was constituted after the case being filed and no leave of the court was taken
Well,
to constitute that committee.
Inquiry report, the government is yet to take a decision on the inquiry report.
That is up to you. You may take decision or may not take decision. This court is not at all concerned because it was not constituted with the leave of the court.
Lordship will record by sufficient ballot that there was no direction prohibiting us to from for making an inquiry.
Where do you got the authority?
Madam.
Where do you got the authority while the
Well,
list
there-
is pending before
Well,
this court?
there is a prayer made in the repetition
Hmm.
where, my lord, in fact, my lord, to respond to this repetition, we need to have facts.
Hmm.
Now, the prayer what has been made in the repetition is directing the authorities to make appointment on the basis of the select list that is prepared by the director of
Okay, all right,
elections.
all right.
And logically, my friend has shown one select list of a Dibrugarh district. man.
Tinsukia.
Tinsukia district.
Hmm.
My lord, this, after it was placed before this honorable court, this honorable court directed us to bring the instruction on record.
Hmm.
Page 242 is the instruction. man.
Wrong, it's wrong. It's wrong way. It is not wrong.
Page 242. There is an order to that effect by this honorable court.
Yes.
Oh.
With reference to the Sabla, I like to state that the Honorable High Court, by its order dated so has directed to verify the genuineness of the document submitted by the petitioner along with the additional affidavit. In this regard, it is mentioned here that as per office instruction dated so submitted the consolidated list of the post of grateful Chokidar which was not signed by the other members of the screening committee. Therefore, the DO Kasar submitted another list of the candidates of the same post following guidelines and producing minutes of the screening committee rejected the said list of the candidates due to violation of the guideline. It is pertinent to mention here that at the time of submission of the list of candidates, DO Kasar never produced the list of the school-wise candidates recommended by the screening committee. Hence, the document produced by the petitioner before the Honorable High Court through additional affidavit.
No, no, this letter is not in respect of the Tinsukia district.
Yes, Lordship, that's why I'm saying he's submitting wrongly. It was, let me clarify.
It is in respect of
Let me
Kasar.
clarify.
Because Tasa district, there was no list, madam.
This is his wrong interpretation, my lord. This is not correct. Tinsukia district, there was only signature of the single district officer, my lord, and that is acted upon, they have been appointed. I have procured this copy and annexed with the additional affidavit. That is the accurate thing. They have stated, my lord, they have taken, conducted inquiry in respect of 16 districts. What the outcome of this Tinsukia district? Nothing. That was also with the single district officer signed.
I'm sorry, madam. This is in reply to the additional affidavit where he have brought this.
I have brought it on record.
The Kasar.
Hmm.
This instruction I could figure to do, madam.
I have annexed with the additional affidavit filed by me
Page
to clarify
225.
their stand, my lord.
Page 225.
They have
This is the instruction with regard to page 225.
And the
the list of the Kasar district.
This is in a respect of not getting salary.
So the list which here produced before this honorable court in the additional affidavit, so that the list were prepared and it was sent, and subsequently the DO has prepared the consolidated placement, the list of the schools.
It is admitted by this honorable court in the earlier round of litigation already, my lord. This is not a fact
No,
that there was
it
no
has
interview.
It has never been a finding of the court member that there were proper lists being prepared by the selection committee.
Therefore, this honorable court directed
And
the
there-
D.
Malad, this instruction clearly says that these documents are not available in the office. The school list. Malad.
Or Mr. B. Purkaisto, Lord Advonsel for the petitioner. And Mr. D. Kosik, learned standing counsel for the respondent in elementary education department. Argument concluded, order is at.
Obliged to see.
Grateful, madam.
The numbers 9 to 12.
All these petitions are related to the pensioner benefit. 9, 10, 11, the serial number 9, 10, 11, is on a similar reply has been given. 12 is they are not filing affidavit. The pleading list has been, I will argue separately on that point. Lordship will call convenient. Lordship make it take number 11. Item number 11. 4952. 4952. All these three 9, 10, 11, all the three cases are similar pleadings. Therefore, I am arguing matter. A common argument will give will do all this matter. The
9, 10, 11, all are same.
oh yes, 9, 10, 11. At 12, I will argue separately. The facts leading to this case. I am giving a short background of the facts leading to the case. All these petitions are appointed on 1980. And after joining his service, they were terminated from their service without due procedure of law. They opposed this honorable court. The honorable court stayed aside the termination order and reinstated them. They appeared that if they have found illegalities, under the notice and due process to be made. They reinstated, they are working in their respective post. They get the regular pay scale. They are sent to the basic training by the respondent authority, and they completed the basic training, and they are supposed to us subsequently confirm all three petitioners. Thereafter, on 2007, suddenly their salary has been stopped. They again came before this court. The honorable court, after hearing allowed this petition and directed them to pay the salary. They filed a government file a review, respondent authority. The petition also been dismissed. Thereafter, they are getting after contempt proceeding and many proceeding. After that, received the salary 2014. Again, their salary has been stopped. When they are discharging their duty, even then government have taken a decision to get person and giving appointed as a tutor. Though they are confirmed before they have a basic training, they accept the order because they are in such a economic condition. There is nothing to think about that. The authority said that their qualification will be considered later on. They join this post and they are on that time they are in the verge of the retirement. And all the petitioners were on 2022. Sorry.
Now they are no longer in service.
Yes. Therefore, thereafter, they joined their service as a tutor and they are retired from their service on 2022. Only after one year of petitioner is 1.5 years, they are working in contestant for more than 30 years. That is the background of these petitioners. They have not disputed, they have filed affidavit, they have not disputed these facts. They said that my appointment is not good, therefore you are not entitled for. They are not saying that I am a tutor, that is why I am not getting the appointment, because I will place the law. Kindly take the petition first. 4952. All these petitions are in same nature. Therefore, page 24, there are first appointment letter. Next, one page 24.
Yes.
They are appointed, and after that, they were terminated, and they came before this honorable court. Page
So,
26. Order.
Your salary was
Page 26
stopped,
the order.
Mr. Borua?
Order copy.
Mr. Borua,
They came before this.
your salary was stopped first in the year 2007.
Yes.
Thereafter,
And then
you have,
that will come. That are all
Thereafter-
give.
no,
Shift.
no, thereafter,
First, they were terminated on 1992, and they came
On-
before this court
when they have been terminated?
in 1992. And
No, appointed in the year
1989.
89.
89. They are terminated. Their
Where is the appointment letter?
appointment is, you will find in page 24 appointment letter. They divorce more.
Page 20?
24.
Yes.
And thereafter, they were terminated in 1992. They opposed this honorable court. The honorable court on
Where is the,
14/11/95.
termination? Where is the termination order?
Termination I am not giving. I came to the judgment where it is reflected. 617, page 26 onward. There's a photostat copy that is not at the time. I give the type copy, Lordship. Can it take? The petitioner before your Lordship were in this case, Lordship, will find the serial number 44 of the petitioner. Petition number serial number 44.
No, you show me the date on which they were terminated.
Yes, yes. 18/5/92 years you will find annex B. There are all are on 1992. I give. They oppose this court. This case is pending for the years who are alleged the service in even 1993. Today are the end of 34. More than 2 years elapsed. I bear by this 18,592. Lordship will find
Hmm.
28. Page 28, the last paragraph. Bear period of Annexure 3. The order dated 18,592. Cancelling the appointment of the whatsoever shown or given. Appointment and given to the petitioner were cancelled without affording any opportunity, without giving any reasons. Therefore, it is a complete violation of the principle of national justice, and they have found a note advancing the statement in the writ petition. And the application is must be accordance with the law. In view of the matter, Annexure 3 order cannot be stand according the Annexure 3 series order terminating the service of the petitioner shall stand first. Lordship, take it type copy. Lordship, it is very readable. And call shall be reinstated.
When?
Reinstated in their service. Petitioner shall be reinstated. It is made clear that if there was any irregularity in making the appointment, the authority may take after giving notice to the petitioner or necessary order in accordance. But petitioner shall be reinstated the service in a period of 1 month from the date of receipt of this order, and salary due petitioner shall be paid after the reinstatement in accordance with
No,
law.
no, when
A-
they are,
And
when,
thereafter, they file a review petition. They file a review petition. That also been filed with lordship,
no,
page
no,
30.
when they have been reinstated in
Oh,
service,
they immediately after they were reinstated.
where is that order?
Reinstated order is, I'm not aware, but that is also reflected in subsequent. It is reflected.
That order
Eh,
is not,
they-
part
they-
of the- that order is not part of the record.
It is not part of the record. Lordship will find. Thereafter, they were after reinstated, they are working, and on 2000, after the review, they are sent to the training. They are sent to the training, report to the training that is required under law, and they are completed at the training course. And that will find in Annexure 32, the pass certificate. These factors are not even disputed by the respondent in their affidavit. No, not disputed. Page 32. And this were, I will come to later on, this will be also reiterated by the court in a detailed order in letter at page 32. And page 33, Lordship will find they are confirmed. Their post has been confirmed.
Page,
Proposal of the
page number?
Annexure 5, page 33. Their post has been confirmed. With effect from 1193. And now at this stage, on 2007, their SLA has been stopped. Stopped.
2000?
2007. And they opposed this honorable court filing a writ petition. Their writ petition number 1293 2008. And the honorable order passed, the lordship will find at 34, page 34 onward. All these petitioners, in the all three petitioners are of one petitioner in this case also. In this case also. The judgment start from page 37. May I read? By the judgment, lordship will clear the background of this case. Page 37.
No, not necessary to read out. Where is the operative part of the order?
Okay. Operative part would be page 39.
last, but in above factual position, there is no alternative but to conclude the petition terms of direction contained in the order dated 14/11/1995, passed by CR 617/93, is on that the rendering the rendering service to the department are entitled to salary. In other words, the petitioner in service and the salary area from September 2000 is paid to them order accordingly. The court observed that these petitioners are only come before this court. And that is why I want to read the judgment because they are all factual part, it will help in the.
Not necessarily, you
Uh,
come to operate.
They said they are appointed, they are terminated, they are reinstated, they working, they are and the order of the 92 is still in existing. Therefore, you now cannot stop their salary. Thereafter, they file a review of this order. That review is also dismissed. That will find lordship which page order will be page 41 onward, and that review was subsequently that the review was dismissed. And even that they have not paid this amount, we file a contempt. They have paid our salary. Till July 2014. And during in the period after that, we are while we are working that the government, in the meantime, government had taken a decision. That will in their affidavit that will reflect. They said that there is a committee. There is a committee, and the committee, the cabinet memorandum has been adopted, and that cabinet memorandum, neither they did it, though they said annex, but they are not giving to us. Cabinet memorandum, I will
No,
place
Mr.
before
Barua.
this court.
So after dismissal of the review.
Kindly
petition-
kindly take the affidavit in opposition of the sorry.
Mr. Barua, after dismissal of the review petition, one contempt petition was filed.
Yes,
Where is that contempt
the
petition?
contempt petition already been filed, that is ordered on basis of order, and we have get the payment.
Till,
Payment was given to us.
till
2014.
2014.
Yes. That statement we have given it.
And where is the order by which they have stopped your salary since 2014? Where is that order by which they have stopped your salary? Since
That
2014?
was a 2007. That was
No.
not singular. No, that is general order.
After disposal of the contempt
No,
petition.
that is a general order. All this salary of the Dhemaji district teachers have been stopped.
Where is that order?
Lordship will find in the judgment itself. That is what, Lordship, I want to take that judgment of this honorable court on the 1 to 90, and there all this factual part.
No, you say
But- But that document I have not annexed with
after-
this deed petition because
after
that is
disposal of the contempt petition,
and
your
that is
salary
already
has
been addressed by the respondent authority. But
Hmm?
that there was a general order was given.
You produce that order, where is that order?
And that order, that order is not annexed, but
Not
has been
annexed, then you bring on record by filing additional affidavit. You are in the air now.
that order, they can
Yes,
give
it
that
is
order.
part of your affidavit.
Oh,
Mr.
they,
Phogat?
I don't know what order he's talking about. Our case is totally different, my lord. I don't know what, my lord, let him complete his, my lord, argument, my lord, we'll place our case.
No, yeah, if
my lord,
they,
my lord, this case is,
according
my
to
lord,
him,
my lord, according to him, my lord, then.
salary has not been paid
Yes, my lord.
since the year 2014.
My lord.
Where is that order?
I don't know what he's talking about, my lord, but what the case which we have made out here is totally different, my lord. There is no locus in this matter, my lord. This case, there is no locus, my lord. Let him complete, my lord. I will place the facts, my lord.
their affidavit, they not disputed that this fact, that cannot be disputed, but that is the already been executed by this court. But they are said that there is a cabinet decision, their version, and the cabinet decision, after cabinet, they have taken moderate procedure, recommendation, and then on basis of that recommendation, and I was appointed as a tutor with some principle, but then and I retired on that. And they said on that affidavit that my initial appointment was not.
No, that's all right. You produce the relevant documents here.
But this is a, my lord, a fit case for dismissal. And my lord, let him complete, my lord. And
Hmm.
whatever he's saying, what order, let him produce, my lord.
That is their document.
Document. That is not the case, what order they are talking, I don't know, my lord. This is a different case totally, my lord. We project it when our part comes, my lord, we'll showcase through the affidavit. Everything is there in the affidavit. my lord. In the affidavit, everything is there. Let them complete their, my lord, file, my lord, and then we'll produce. Already it is filed in the affidavit. Nothing more is required.
Mr. Borua, where is the document to show that you have received salary till 2014? Where is the document?
That is categorically stated in paragraph.
No, on the
Paragraph
basis of
19.
your statement, we cannot issue order.
I will place the document. There's a after this contempt proceeding.
Hmm.
They are hiding that. I will not do hiding this. They contain after contempt proceeding. There are two contempt proceedings has been initiated against them, and thereafter they compelled to give, and they, I have a document. They make a payment it post, and they release it. I have that document. I can give it. Yeah, I can give it. That is, we are not disputing on that, and they are not disputing.
All right. Heard Mr. Borua, learned counsel for the petitioner. Mr. A. Fukun, learned acting counsel for the respondent in Elementary Education Department. Mr. B. Sharma for.
Oh, their part has been, they have already done. GPF amount they paid.
And Mr. Madhi for. Item number 10 for AZ. AZ. Okay. Recessal list the matter parted on. In the meantime, Mr. Borua, learned counsel for the petitioner, shall bring on record the order by which the salary of the petitioner were stopped by the respondent authorities since
Yes.
2014.
And Lordship, I can pay because they have in their affidavit, they said that regarding the annex of the cabinet memorandum in their affidavit, but they have not annexed that cabinet memorandum.
You enclose with your additional affidavit. Mr. Borja shall
yes.
also
But,
bring on record the cabinet
I'll bring that on the record.
by along with the additional affidavit. Yes.
Lordship, I'm sorry to mention, not taken well, that's why Lordship. Number 24.
24.
I'm also told that records are not there. Matter may come after.
After a week. On the pair being made by Ms. S. Kanangu, Learned Counsel for the petitioner, with consent from the other side, the matter is then adjourned to be listed after a week. Yes. Okay.
On 11th December.
Lordship, no, it has been filed as continuous.
Mm.
This on the record. Maybe one. What? All the.
Okay.
Other number 13.
May it please, my lord. My lord, this matter pertains to, my lord, the petitioner not been given any salary since the month of April 2018, my lord. He's an assistant teacher at Nabarangpur High School, my lord.
Where is your affidavit?
Lordship, we have received instruction on 15th November, my lord. We may be allowed some time to file our affidavit.
My lord, they have been.
No, on the 10th, you have been given the last opportunity.
Yes, my lord. Instructions with me, my lord. There were certain anomalies, my lord, while resuming his duties, my lord. That I may be allowed to bring that on record. Sometime.
My lord, he is about to retire on 26/11, my lord. And if kindly comes to page number 35, my lord, there was page number 35. Just I'll point out two things.
No, Mr. Iqbal, you see, can we dispose of the matter without their affidavit?
They have already filed one affidavit that is on record, my lord. This is an additional affidavit they wanted to file. Just to clarify their previous stand, my lord. Because along with the affidavit that they had previously filed, they have not produced any documents, my lord. Although in the affidavit it says that to the reasons based on from the belief of documents, my lord, but no documents have been produced. So they sought time to file additional affidavit seeking clarity, my lord. So they have been taking times, my lord. And the petitioner is about to retire. And till today, my lord.
But when did you file this petition?
February 2025. There was a delay on our part because, my lord, the petitioner was.
Now you are pressing the matter so hard that without their affidavit, we have to hear you.
Then, my lord, may kindly give them a short period, my lord. Let them file, the date it comes on next Tuesday, my lord.
No, my lord, it cannot be, my lord. At least 1 week time, my lord.
They have their record, my lord. How much time?
Yes, I have it, but, yeah.
No, in that case, you have to pay some cost.
1 week only, I bring for 1 week, my lord. Because,
You see, on 10th of November, you have prayed for last opportunity.
Lordship,
We have granted you.
on
You have
15th
failed to avail it. What to do?
89 also they had taken time, my lord.
There
If
was
my lord
no
goes
instruction on that date,
89
my lord.
also.
Today we have the instruction with me, my lord. One
Heard
week,
Mr. Iqbal, Learned Counsel for the petitioner. Ms. Bora, Learned Counsel, appearing for BTC, submits that though last opportunity was granted to her to file additional affidavit, yet she could not file the same as though she has received the instruction. And she pressed for granting her 1 week time to bring on record the said instruction by filing an additional affidavit thereof. List the matter on Monday.
Ma'am,
On 24th.
oh, blessed.
Other for bail hearing. Item number 14.
May I please have a-
Hmm.
Actually, I'm after the matter for the time being. Help are available in the moment. You will come.
You see, this petition was filed on, who is that you have filed the petition?
No, so it was, I think in August, in the first week. of August.
There is a direction of Supreme Court to dispose of the bail application within 2 months.
Actually, he will come.
Okay. Okay.
Item for orders, no stay. Item numbers 25 and 26.
Non-appeals for the petitioner on call, list the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Item 15 for orders.
26 same.
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 Lordship, the matters will be passed at the time being. The Arguing Council is on legs, sir.
For the should pass.
Completely.
Who is the arguing counsel?
S. Hazarika, Mr. A.
Pardon?
Mr. S. Hazarika,
Yes, already. Okay. After some time?
March only.
The service is completed, I have.
That's right.
No? So let the matter be listed for admission hearing because service is completed.
And we are also not going to find,
I'm of course not going to find.
My lord,
yeah,
I'm
yeah.
sorry, my lord. My lord, here's the similar situated case, my lord. There are 5 writ petitions already been disposed of, my lord, by this honorable court, my lord. And the direction was to redo the select list of the all the, my lord, dates, my lord. And the process has already been started, my lord. So I'm just placing the,
Process has already been started.
yes, my lord.
yes, Lordship,
Seniors and some of the juniors are included, my lord.
Now what to do? We have to close the petition.
Yes, my lord. As for similar order may be passed.
Huh?
Similar order may.
can it be passed? কারণ আগতে দিছে।
Oh, this is. Paragraph 15, my lord, can be parrot, my lord.
So, okay, then. Passing similar order, we will dispose of the petition.
My lord, my lord. Obliged one.
Nonetheless,
Item number 27 and 28.
That's for the last order.
you have filed the affidavit?
Affidavit today, my lord.
When?
Today, my lord, served the copy. to-
File it, I guess. Affidavit.
I found it. Not on record. Never mind.
We can wait for a few times, few minutes. I have already, requisition already submitted.
Take up next week, my lord,
No.
along with the petition, along with the affidavit.
Lordship, some urgencies there, Lordship. I have gone through this affidavit. In this affidavit, Lordship, and the last locations, the instruction was sought. Everything is same, Lordship. Here is stand is taken, Lordship, that the enrollment number of the student.
No, you say, before me, the affidavit is not available. Without
Lordship, we
going
can
through
wait
it-
sometime, Lordship, then after few minutes, Lordship. I have submitted the requisition slip, Lordship, in the filing sections. So it is coming on the way, Lordship.
Correct. So let us fix it on Thursday. Thursday.
This-
I said. Okay, then after some time, the
Sometime. Thanks.
Oh, here is. I mean, that's 17.
Lordship, they may be taken up after some time, Lordship.
After
Time
some
being.
time. Who will appear?
Chip,
Who will appear?
H.K. Das, my senior, Mr. H.K. Das.
Section 18.
Eight, please, your lordship. And for the respondent,
Appellant is not present.
the junior counsel is.
Oh,
His. With you. Maybe can after some time.
after some time. Okay, then after some time. Okay, next.
Item 18.
21. Item 21.
I filed an additional affidavit
When?
on 3rd of August. Date of receiving is 14th of November 2025. I have supplied a copy to the opposite party. This is regarding the document which has been pointed out by the Honorable
Who is appearing for opposite party?
Mr. Kabra is there. He was present in the morning.
Kabra.
Yes, Mr. Kabra and Mehul Shah. Councils are there. The main counsel is coming. She is appearing on behalf of the respondent as a proxy counsel.
Okay, this is not on record.
The Honorable Court has pointed out that the document was not on record, which was mentioned by me, that the same has been placed on record by the respondents before the trial court. It should be available with the present, before the present Honorable Court at the time of hearing the appeal. I am having the certified copies and copies received by me from the respondent at the time of trial before the Honorable Court.
But your affidavit is not present in the court now.
I have filed, I am having the receipt and I have also supplied the copy to the respondents. I filed the documents because the Honorable Court has pointed out that the said documents were not on record.
Ase. So let it be on a Thursday. In the meantime, Resti will take the matter, take the affidavit with the record.
Can it be in the month of December or 17 or 18, because I am coming from Delhi and.
You are coming from Delhi?
Yes.
Okay.
18th of December, because I am already having another case before Guwahati High Court. 18th or 17th of.
Okay. But the thing is that there is one office order that one matter can be kept as part-heard only for 30 days.
Yes, but it is my humble request for the Honorable Court, because I am coming from Delhi. Already short dates have been given by the Honorable Court. I am appearing on each and every date. It is my humble request. Can it be fixed?
Heard Mr. Sharma, learned counsel for the appellant. Then also heard Miss.
Sachit Sharma.
You
Sachit.
for? No, you for?
Yeah, for respondents.
Your name, please.
Sachit Sharma.
A. Cabra,
A.
A.
learned counsel for the respondent.
Lordship, can I speak some?
Yes.
Respondent Kamala Ladha, she expired on 25 October.
Okay.
But the present matter has been contested behalf of the Kamala Ladda by her power of attorney holder. Now I will place on record the requisite application for placing on record the legal aid.
Yes. You have to file implement petition.
25th.
The learned counsel appearing on behalf of Mr. A. Cabra submits that the respondent, Srimati Kamala Ladha, already suffered demise when?
25th October.
25th of October 2025.
Yeah.
Accordingly, it is provided that the appellant shall take step for bringing on record the legal representative of the respondent, Srimati Kamala Rava. The learned counsel for the appellant also submits that he has filed an affidavit, additional affidavit bringing on record certain document, but the same has not been placed on record. Accordingly, it is provided that recessal is the matter on 17th.
Or 17th, any of the date in December.
Or 17th? 18th.
18th.
But you have to file the petition before that day for implement of the legal.
Implement, I will file before the next day.
Okay.
Yes, yes.
Yes, you will file application. Okay.
Number 22.
Yes, yes.
Last occasion, I paid number court to submit to you.
Mm.
I have wait for compilation. Points of argument.
Okay. Heard Ms. Talukdar, learned counsel for the petitioner, and Mr. S. Das, learned standing counsel for the respondent in higher education department. Person to order dated 4/11/2025, Mr. Das has produced the relevant judgments upon which he has relied on. Judgment reserved.
Lordship, I want to produce my judgment. Please speaking. In front of the class.
Item number 23.
Here is left before another plot, and the matter will go for the time being.
You are for the respondent,
Yes, Lordship.
but who is for the petitioner?
Senior A. Das Gupta is there, Lordship.
For the petitioner,
Yes.
but no one is present today. So none appears for the petitioner on call. How about Miss
S. Yasmin on behalf of M. Sharma.
S. Yasmin, learned counsel appearing on behalf of Mr.
M. Sharma.
M. Roy, learned counsel for the respondent. M. Roy is for the respondent or petitioner? Respondent.
You go.
But in the order dated 19/8/2025, it is stated that M. Roy You are for M. Sharma?
Yes.
Okay. How about Ms. Sorenson, Learned Counsel? For Mr. M. Sharma, Learned Conducting Counsel, put a respondent number 125 present. List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Turning measures. Item number 27 and 28 for orders.
The page 60 of the affidavit.
60.
Is the judgment and order, madam, which the content is being alleged. Fine, the direction is at page 20 minutes. Okay, fine, page 7. Paragraph number 19, 20, 21 and 22 are the directions.
20?
Paragraph number 19, 20, 21 and 20. There are threefold direction minutes. First direction is page 20 minutes. Page paragraph 19 in the order setting aside the earlier decision of the high power committee. Now the further direction is in view of the fact that the order dated 18/1/2021 has been interfered with by this court, on arriving at a conclusion that the grounds as assigned for rejecting the case of the petitioner therein are clearly not sustainable. The matter now remands back to the Director of Elementary Education, Assam. Now place the case of the petitioner before the High Power Committee or any other committee presently in existence for considering the case of the petitioner for provincialization in accordance with the decision of this court relating to declaration of services of the drop teacher, as well as the policy as contained in Office Memorandum dated 13/01/2020. So this is the first direction of the Director to place it before the High Power Committee. So the High Power Committee is a court appointed committee in terms of the order of the division bench. So the second direction is to the High Power Committee. Paragraph 21. High Power Committee shall strictly consider the case of the petitioner in terms of the Office Memorandum dated 13/1/2003 and the decision of this court rendered in the case of Tapan Chandra Das. Now the third direction is, my lord, based on if the High Power Committee recommends, then the role of the department will again come. In the event the High Power Committee recommends the name of the petitioner for provincialization of our service, on consideration of our case strictly by appreciating the factual position available with regard to the service rendered by the petitioner in the said school, such provincialization shall be effected with effect from the date of the other similarly situated drop teachers came to be regularized in their service in pursuance of the Office Memorandum dated 13/01/2003. The other service benefit of the petitioner shall also be extended towards strictly applying the provisions applicable in this connection, as the other similarly situated drop teachers were regularized in their.
So, Mr. Kaushik, you tell me whether High Power Committee was a party in that proceeding, rate proceeding,
In this
earlier rate proceeding?
earlier regulation of. Let's see, it's the party. Yes, it is the respond number 3.
Respondent number 3. But whether the respondent number 3 is a party in this contempt petition?
Only the member secretary has been made a party. Although the decision has been taken by the Hyper Committee by all the members. Like if Lordship will kindly see who are the members of the Hyper Committee of CHP1. It will be verified by the. Let me complete. Here in this order, it's the whole portion is not there. That's why my friend is saying. Respondent number 3, committee represented by them. So, chief committee is represented. 81, my lord, will see the constitution of the.
Yes.
The chairman of the Hyper Committee, my lord, finds the member secretary. One member is the secretary from the faculty. And one member is the director of the secondary education. There are 4 members in the. What has happened? Pursuant to after this contempt is being filed, the
No, you tell me, who is appearing in this petition for the high power committee? In this contempt?
Secretary.
proceeding?
Secretary.
Secretary.
Narayan Kaur.
You are, Mr. Kaushik, you are representing secretary,
this affidavit is being filed by the secretary.
this,
By the secretary.
okay.
Now, your lordship will kindly see. Now, first, when the director of elementary education has forwarded it to the secretary for placing it before the high power committee.
No, in this contempt proceeding, whether the secretary is a party,
Yes.
high power committee,
High power.
he is representing the Government of Assam, Elementary Education Department, secretary. Mr. Hawk,
He also represented lordship in my 8 petitions. I have a party one of the member.
And being a member secretary, his role in the high power committee, partly to place it before the high power committee, equal the factual position of the department. And if your lordship will see the minutes of the high power committee, may I just point out first before this one, that after this contempt was filed with us, the former chairman of the high power committee retired on attaining the age of superannuation. And thereafter, this new committee, the present committee, was constituted. Now, this committee, my lord, initially took a decision on 12th of March 2023. 2025, sorry. 2025. In compliance of the ongoing course order, the high power committee rejected the claim of the Now, clear the will in 2025, apparently, my lord, this honorable court in 24/9/2025 order in the contempt proceedings has observed that it is a reiteration of the earlier rejection. But the direction of this honorable court was very categorical, that the High Court committee has to take a decision based on the office memorandum of 13/1/2003.
no, Mr. Kaushik, this affidavit is filed by the secretary to the Government of Assam
Department of School Education.
in his capacity as secretary to the Government of Assam School Education, but not as the secretary of the high power committee.
Also the member, ex officio member secretary. By virtue of his posting as a secretary to the Department of School Education, he becomes the ex officio member secretary of the department.
But the question is, unless he is made a party in this proceeding, how can we draw up the proceeding against him?
That's what I was on the last day saying, that if your lordship finds that the high court committee's decision is contemptuous, all members have to be a party in this high court.
No, not necessary. If the secretary of the committee represents all the members, then it will suffice.
Because it is a my humble understanding. Because if your lordship holds that the committee has committed a contempt,
Oh,
and the members
all the members,
because all the decision has been taken unanimously by all the
maybe.
members.
Maybe.
Now, more importantly, my lord, if your lordship will kindly see, in paragraph 21, my lord, what was the direction to the hyper committee? Is 70. The hyper committee shall strictly consider the case of the petitioner in terms of the office memorandum dated 30/01/2003 and the decision of this court rendered in under task. Now, my lord, the office memorandum from 13/01/2003 might not be filed at page 72.
Yes.
First, there are 6 conditions which has to be seen by the higher sector. The teachers must be in at least 2 years of continuous service immediately proceeding the taking over of the concerned school by the government. The appointment of the drop teachers must have been duly approved by the concerned district elementary education officer inspector of school. Third, the appointment of drop teachers by the managing committee must be commensurate with the enrollment of the students in the school at the time of provincialization. My lord, take note of this. The school-wise norm of number of section posts to be maintained. The provincialization particulars submitted by the district elementary education officer inspector of school and available in the respective directorate will be used as a reference document. The teachers fulfilling the above criteria will be considered for regularization of their services subject to the availability of the sanction post in the concerned district. So these are the criteria which the hyper committee has to look. Now, if you also will kindly turn to the minutes of the hyper committee at page 76. Like your lordship attended to the second line, Miller, of the minutes, Miller, where your lordship will see that the chairman and the other members of the committee were briefed by the member secretary, Miller, which before your lordship. In respect of the cases to be placed before the committee for examination. The following case was placed before the committee for examination. Contempt case number so and so, background. The petitioner then approves the High Court in the ongoing contempt case. Then within the court, my lordship's observation of in the order dated 24/9/2025. That was also briefed to the High Court committee by the government. The High Court committee meeting dated 24/09/2025. In compliance of the High Court order dated Honorable High Court order dated 24/09/2025 in contempt case number so and so, the matter was looked into afresh in the meeting dated 24/10/2025. After careful examination of the matter, the committee instructed the concerned directorate to submit a detailed report as to whether the petitioner fulfills all the criteria laid down in the office memorandum.
No, you come to the decision of
No,
the.
Malab, your lordship will kindly see this. This is
Which
important,
one?
Malab.
Which one?
The
It's 77.
page 77. Because the direction was to take note of 13/01/2020 whether that exercise has been done or not. It is just after the High Court committee meeting dated 24/09/2025. Because this was again relooked after your lordship's order. After careful examination of the matter, the committee instructed the concerned directorate to submit a detailed report as to whether the petitioner fulfills all criteria laid down by office memorandum dated 13/01/2003. Director Elementary Education was instructed to elaborately examine the following points and submit a report at the earliest. Now, these points are the points which your lordship have read in the office memorandum 13/01/2003. Then, my lord, the committee examined the report submitted by the Director of Elementary Education by letter dated 7 November 2025. The report of the Director of Elementary Education. The school of the petitioner so and so provincialized in 1980, letter dated so and so, as per given below. These tables are there. In this connection, as per the any madrasa staff pattern as the minutes of the SLC for considering the permission, recognition, upgradation, concurrence of the institution held on 2005 in the office chamber of the and this office letter number so and so. These are the numbers of posts. Due to the legal dispute, government passed an order to keep the provincialization of Koimari ME School Madrasa headed by so and so. PMS. Thereafter, on the basis of the report submitted by the PEO Golokal, government issued order dated so and so, whereby provincialization order was kept in abeyance was vacated. Accordingly, the service of the temporarily approved by the DEO by letter dated so and so were provincialized based on the number of sanctions as per the details below. These are the provincialized. Being agreed for non-provincialization of services of the teacher, the petitioner filed WPC number so and so linked with this so and so in both the cases. Matter was placed before the Hyper Committee dated 22/12/2014 and 9/12/2019 respectively. Both the committee has rejected the claim of the petitioner according to the government issued order dated 5/2015 and 18/2021. Now the petitioner filed WBC number 4689 and the Honorable Court passed order dated 21/2 whereby setting aside the government order dated 18/1/2021 with the direction to the DE to place the case of the petitioner against the committee to consider the case of the petitioner for population in accordance with the policy as contained in the memorandum dated 13/01/2000. Further, the committee thoroughly examined the elaborate reports of the DE submitted against the 5 points laid down in the office memorandum dated 2003. Now, here what relevant would be B1, because this is the ground of rejection based on the report of the director. Was the appointment of the petitioner by the managing committee commensurate with the enrollment of the students in the school at the time of provincialization? As per minutes of the state level committee for consideration of permission, recognition, upgradation and concurrence of the educational institution held on 2005, the minimum enrollment in one class should be 30, and there are more than 55 enrollment in a particular class of the school to be opened a new section with prior approval of the DE after fulfillment of necessary conditions. In the instant case, the class-wise enrollment as furnished by the BEO Agamani for the year 1996 and 2008 are this one. The years was now I'll not.
Why only 2 years attendance has been considered?
Because these are the 2 years when the provincialization was taken into consideration for us. Because the clause 3 of that office memorandum says it should be at the time of provincialization of this.
But this school was provincialized in the year 1980, Lordship. So this point is not come. The record is reveals that was provincialized in the year 1980. There are other 3 cases. Captain AV, that order has been passed and Captain AVS of the fourth session. That's in the year 2008. That Captain AVS order was vacated. So ultimately, Lordship, this it's not provincialized in the year 2008. Wrongly interpreted, Lordship. So everything is clear, Lordship. If kindly see the order finding of this Honorable Court, Lordship, is everything clear, Lordship. This Honorable Court came in conclusion finding that the present is not an ex-petitioner. As per their versions, now rejections ground that present petitioner is a ex-petitioner.
No,
But
that's wrong.
Right.
Page 81 is the decision.
Lordship, they say enrollment now.
Okay, wait, let him complete.
Your Lordship has seen that the enrollment position as it is required to be seen under the office memorandum, which is the direction of this Honorable Court. That was seen, and then the committee has decided in page 51. Committee has thoroughly examined the report of the DE Assam.
No. Mr. Kaushik, what is the basis of putting this here in this order 1996 and 2008?
Yes.
But 1996
If the attendance has to be considered on the date of provincialization of the school?
that your Lordship will find page 78, just below the second table, my lord. Second table, second bullet point, my lord. On the basis of the inquiry report submitted by the BEO issued by letter dated 4/8/2008, whereby the provincialization order which was kept in abeyance was vacated. So this is the period, my lord, where the provincialization again has been taken into consideration. And subsequent to this, the provincialization has been, the service has been provincialized.
No. Only the kept in abeyance order was vacated
Yes.
in the year 2008.
Yes.
Well,
So that is not the date of provincialization of service of the school.
Yes.
services of the teacher temporarily approved by the letter dated where provincialized. So, but the provincialization was, first provincialization was 1980. 1980. Thereafter, it was kept in abeyance. For the this 2008 has been taken into consideration because
So,
that kept in abeyance is vacated.
So which date is to be taken into account? The date of provincialization or the date of vacation?
But even if the date of vacation is taken into consideration, in that day also the enrollment was not the less manner.
Lordship, I am going to that point, Lordship. That is completely manufactured, Lordship. That today my client has been informed, Lordship. that Whatever number is given,
Let him complete.
Lordship.
But there are based on the decision, your lordship will kindly agree to page 70, my lord. This is direction of this honorable court, my lord. Our direction was to place it before the hyper committee was to the director, my lord. But the director forwarded it to the secretary, my lord, and secretary has complied with the direction, my lord, in my respectful submission by placing it before the hyper committee. Thereafter, based on the observation that has been made in this contemporary proceeding, my lord, in 24/09/2025, by your lordship, that the decision of the hyper committee has not taken into consideration as directed in paragraph 21. The office memorandum of 13/01/2003. Therefore, my lord, the secretary, my lord, the respond number 1, being a member secretary and being a party in the contempt proceeding, has again placed it before the hyper committee and has briefed him, my lord. The lordship has seen that the member secretary has briefed him with the correct proposition and the position of the in the contempt proceeding, as the other members are not a party to this contempt proceeding. Thereafter, my lord, the paragraph 21 direction is the hyper committee shall strictly consider the case of the petitioner in terms of the office memorandum. Now, the decision, whatever has been taken, that decision has been taken pursuant to a detailed report that is submitted by the director, and the report was called from the director based on the requirement that is in the office memorandum. As my lord, in my respectful submission, my lord, as it is a contempt proceeding, the hyper committee has taken a decision taking note of the office memorandum dated 1/3, the requirement of the office memorandum of 13/01/2003, to give effect to the conditions laid down in the office memorandum. A report has been called from the concerned directorate. The directorate has submitted this report. This is a report of the director of elementary education. So based on the report that was submitted by the director of elementary education, Assad, the hyper committee at page 81 has taken this decision in compliance of the direction at paragraph 21. The committee has thoroughly examined the report of DE Assam, and it is also observed that although the petitioner is found to have been rendered in continuous service of the school for 2 years, immediately preceding the taking over the government, given the effect that the school was provincialized in the year 2008. However, the appointment of the petitioner by the managing committee does not commensurate with the enrollment of the students in the school at the time of provincialization. The petitioner was appointed as an additional teacher and she was not promoted to the post of assistant teacher. Considering the low enrollment in the school at that time, no additional post was required to be created. So, in my respectful submission, the direction of this honorable court, the hyper committee, is to take a decision in terms of the office memorandum. There was no mandamus to provincialize the service. Hyper committee has taken a decision. Right? But if my friend says that this hyper committee's decision is incorrect and the report of the director is not factually correct, he'll have to challenge this, in my respectful submission. Because the direction is complied with. Now, the secretary.
Okay, all right.
Yes,
Yes, what is your context?
Case 82, your lordship.
Okay, all right, all right.
Case 82.
Okay, all right.
Lordship, in this
Yes.
case, Lordship, this whatever finding of this hyper committee is apparently not correct, Lordship. That's because, Lordship, this High Court came into finding that a petitioner is not access teachers. Kindly see this finding, Lordship. There is page, in my contempt case, Lordship, page 11. And 11th paragraph, Lordship. 10, 11, 12, and 13, Lordship. In this order, Lordship, the whole order, every paragraph is most important, Lordship. Yes, because in this several time, Lordship, one by one, this honorable court allows speaking and they are rejecting, Lordship, in the different view, different stand, Lordship. So in this case, it is admitted, Lordship, the school was provincialized in the year 2018, and that school was Captain Avians after few months. And that school Captain Avians orders going on till 2008. And during this period, Lordship, including the peasant petitioner, all the petitioner, all the teaching, non-teaching staff was appointed by the managing committee. And managing in the year 2008, Lordship, when the provincialization order vacated, Captain Avians order vacated, all the teaching, non-teaching staff got their benefit, Lordship, from the date of joining, except peasant petitioners. So in this circumstance, Lordship, since 2010, this peasant petitioner is approaching before this honorable court, and several petition has been filed, Lordship. So ultimately, Lordship, in this case, Lordship, paragraph number 11, and you see. Lordship, kindly see the paragraph number 10, then Lordship. Paragraph number 10, Lordship, the first ground as assigned by the High Court Committee toward the rejections of the case of the petitioners for provincializations of her service.
Paragraph number
10, Lordship, that is page 70 in my content petitions.
Yes.
Lordship, the first ground there, Lordship, there's a first ground has been taken, Lordship, as assigned by the High Court Committee toward the rejections of the case of the petitioners for provincializations of her service, that she, being an additional teacher of the said school, was not entitled for having her service provincialized. In the fact and circumstance of the present case cannot be sustained. Lordship, the first ground is gone. Now, second finding. The appointment of the peasant petitioner was so necessitated on account of the fact that there was a necessity of a graduate teacher. That is important, Lordship, graduate teacher in the school, and the recognizing such necessity, the school managing committee had proceeded to appoint her as a teacher in the said school. The non-managerial staff as assigned to the petitioner on her such appointment of being an additional teacher is of no consequence in as much as the said designations given by the school managing committee when the said was at the financial stage cannot be held to mean that the petitioner was an access teacher. Lordship, that is important. Now, Lordship, a perusal of the materials brought on the record does not reveals that the appointment of the petitioner in the said school was in excess of the requisite number of the teachers mandate to be appointed in the said school. Further, it is not the contentions of either of the High Court Committee and or the respondent authority that the petitioners appointed as effected on 4 to 1996 was in excess of the requisite number of the teachers mandate to be available in the said school. But now, Lordship, very important, Lordship. Now, Lordship, second and another paragraph, Lordship, paragraph number 13. The petitioner could not have been denoted to be an additional teacher. Also, on the ground that the authority, while provincializing the service of the serving teachers in the said school, had only sanctioned a limited number of this post of the teachers of the effecting such provincialization. It is to meet such situations that where there are more number of teachers working in the said school than the number of the posts as sanctions, that the government had adopted a policy and available in the office memorandum dated so and so, and accordingly the rejection of the case of petitioner on the ground that she was appointed as a additional teacher of the school is clearly perverse. Lordship, why this court came into finding that the peasant petitioner was not access teachers, Lordship? As because, Lordship, kindly see there in their in their hyper committee's present court, Lordship, it is clearly mentions, Lordship, that one headmaster, two assistant teachers, one science teachers, one Arabic teachers, one Hindi teachers. So Lordship kindly, Lordship, there is a two assistant teachers, one science teacher. Why, Lordship, my submission is that, Lordship, code is coming to finding that it is not exists as because there was a post was there, Lordship. Post was there. So kindly see, Lordship, in my read petitions, Lordship, dispose. Here it is. Lordship, there it is clear, Lordship, it is admitted. There is one headmaster, two assistant teachers, one science teachers, one Arabic teachers, one Hindi teachers. So, Lordship, here in this case, what happened? In the year 2004, the original headmaster was retired. So that's why the present petitioner, the second senior most teacher, she become a headmaster. So that's why one post was remained vacant as an assistant teacher. So that's why, Lordship, the present petitioner also submitted an representation that I may be promoted or adjusted as a assistant teacher. So that's why in that circumstance, Lordship, this honorable court came into finding that no, there is present petitioner is not a exist teacher. That contention. So it is clear, Lordship. So high power committee, how this finding can be overlooked, Lordship. In their finding, Lordship, that ratio was less, but that also not correct, Lordship. As because, Lordship, they did not submitted any documents, Lordship. As because today morning, Lordship, my client has been informed, Lordship, that at that time the student ratio is 170 was there, and they are saying now 41 or 52, Lordship. Lordship, can you see the legal provisions? How much students is required? It is clear. Just 40 students is required. In this case, Lordship, my case is covered in the year 1977 rules, not present rules. I think that conclusion is conflict. Yes, I think my friend is not clarified that point. In this rule, Lordship, kindly see. Assam Elementary Education Provincial Rule 1977. Lordship, here it is a
Page number?
Lordship, page number 302. 305 is the rule is conditions for taking over the elementary schools. Second sample is important, Lordship. Enrollment in each of the school shall not be less than 40 in case of the lower primary school and junior basic school, and 90 in case of ME and MB and senior so Lordship.
Which rule you were reading?
Lordship, 5 sub rule 2. 1977.
Yes.
So my Lordship, my first submission is that, Lordship, whatever report has been submitted regarding the number of this student, it is a completely false, Lordship. As because, Lordship, they did not now, Lordship, they did not submitted the documents where they can say 81 student something 51 student was there. Today my morning instructions, Lordship, 117 student was there. And Lordship, kindly see the intention of this hyper committee from beginning. Several times has been rejected. One by another stand has been taken. Whether this is the proceeding, Lordship, whether this is the law, they are taking every time a different view, and every time this honorable court set aside that view. In this case, Lordship,
Okay, Mr. Hope, you implicate the secretary in this proceeding?
Your Lordship, if put the question to me, why 1996, my lord? Because the school was initially provincialized in 1980.
Hmm.
And the petitioner was appointed on 4/2/1996 because at the time when the school got provincialized, petitioner was not there.
Hmm.
His appointment is 4/2/1996.
Lordship, just not for me, all the staff, all the teaching, non-teaching staff. After
Page 61.
after
Malad,
80.
The date of appointment is recorded. Page 61.
Hmm.
Third paragraph. The petitioner was appointed by the school managing committee of the school on 4/2/1996. Therefore, 4/2/1996 and 2008. Because 1982 petitioner was not even there. And Manoj, in fact, this honorable court directed us to take into consideration two aspects. Manoj. One is the office memorandum and the decision of this honorable court in Tapan Kumar Das.
Hmm.
Tapan Kumar Das, this point was there. Manoj. Paragraph 8 in that judgment.
Hmm.
I just read it.
Hyper committee has taken a
View that
unlike any and high school.
who were required to submit a list of teachers
Hmm.
who were working along with the student population, which provided a rational and objective basis for determination of the actual need of
Hmm.
teaching staff of the school, which in turn facilitated the identification of the drop teacher.
Hmm.
There was no such requirement in the case of LP's teachers. That was an argument.
Hmm.
An argument has also been offered by
So and so, London Department of the Council that the LP school is in absence of any such requirement may have recruited a large number of teachers, out of whom only a few were really necessary.
Hmm.
That was all such other teachers to be understood as the drop teachers because their services were not provincialized at initial stage. So and so has also drawn the attention of the court to the specific finding recorded by the Hyper Committee that at the time of the provincialization of LP schools, posts were sanctioned on the basis
Okay,
of need.
you furnish a copy of that decision to this court.
Lordship, it is, I have annexed Lordship in my petitions.
Okay,
That is a-
now you implicate the secretary of the high power committee in this proceeding. Heard Mr. Hawk, learned counsel for the petitioner, Mr. Osik, learned counsel for the contender number 1 and 2. It appears from the judgment and order dated 21/3/2024 for violation of which this contempt proceeding is initiated. The high power committee represented by the government of Assam Education within bracket elementary department was arraigned as respondent number 3, but in this contempt proceeding said respondent number 3 has not been arraigned as a party. In order to adjudicate the dispute in this contempt proceeding, the said secretary of the high power committee is required to be implemented as a party, and in that view of the matter, the learned counsel and the petitioner is directed to take necessary step within 2 working days from today to implement the secretary as party in this contempt proceeding listed on Friday.
Friday and Sunday.
Monday, Tuesday. Okay, Tuesday.
25th.
Serving item for bail hearing, item 40.
Please, your lordship. Regular bail application, lordship. The accused has been behind the bars
For how many times earlier it was rejected?
lordship, as per our knowledge, it has been rejected twice.
Twice.
The last bail rejection
Twice.
has been enacted.
Are you sure for 2 occasions it was rejected?
Yes.
Mr. Kyle, is it the correct?
Yes.
2 times.
The last rejection order has been annexed. It is 7.
Page?
Inside. It has
Page?
been inside for 4 years.
Page number
Lordship, number 87.
87. Yes.
He has been inside for 4 years, 24 days today.
For
4 years, 24 days.
424 days.
4 years, 24 days,
4 years.
1,485 days.
When the charge was framed?
Five been examined. Out of 8 witnesses, 5 been examined.
No, how many, no, on which that charge was framed?
The lordship charged on 17 February 2024.
17 to 2024. So how many witnesses have been cited in the charge sheet?
8 witnesses, lordship.
8. How many of them examined so far?
5.
But as per the record, only 2 has been examined. As per the record available now.
You have enclosed all the evidence of the witnesses here? All the 5 witnesses?
No. But we have checked up the e-court, where it is reflected that 5 witnesses were examined out of it.
So we have called for the record. Have you seen this?
Fine.
Yes, next.
Lordship, this person has been arrested solely on the basis of the co-accused statement. Nothing has been covered from him. No recovery, no direct link of this person with the contrabands recovered.
Maybe, but this issue has already been dealt with in the other bail application.
Lordship. But Lordship, we shall also consider the length of detention. It has been almost over 4 years now. The minimum punishment is 10 years. It's almost half of that. That also goes for the Article 21 violation, Lordship. This
No,
person in this.
Madam, you simply cannot submit that Article 21 is violated.
Lordship.
Who is responsible for this for delay of this
Lordship, if we go through the
almost for 5 years?
if we go through the Lordship, delay has been, we are not responsible for the delay, the petitioner.
But are they responsible?
Lordship, there are dates that have passed without witnesses.
Pardon?
Lordship, dates have
No,
passed without the
whether they
witnesses
have
appearing.
taken a step on each and every date after the order being passed by the court?
I'm not aware of that.
Not aware of. Then how can you contend that your right to guaranteed under Article 21 of the Constitution of India is violated?
Lordship, but dates are passing by.
Maybe that may not be the correct proposition of law. Have you gone through the A.R. Antulis case?
The thing is, Lordship,
You have to establish that on account of their fault, the witnesses could not turn up.
Lordship, that in that case, Lordship, the court can also be held responsible because they are not.
Court can be held responsible.
No,
For?
not in that sense, Lordship. Dates are passing by.
Hmm.
We are appearing. The petitioner side is appearing.
No.
Witnesses are not
The
turning up.
question is whether they have taken a step to bring the witnesses on fixed date.
That I'll have to check.
You have to check.
Again.
Hmm.
Because I think I have seen some orders where it was written that petition has been filed because witnesses have not turned up. Most probably steps were taken, the witnesses did not turn up.
Then whether on account of that that ground they can be held responsible.
Lordship, the petitioner should not be suffering because
Hmm?
of the delay. He has
No,
been
that's all
inside
right.
for 4 years.
But what is the ground for delay? Hmm? You have to establish that the prosecution has not been taking any step. You show me from the record on who is that the witnesses did not turn up, and whether the prosecution side has taken any step on those dates or not. Record is available before the court. You have never checked it. You come prepared on Thursday at 2 p.m. Because
EW5 was examined on 18/8/2025.
18/8. Whether all those evidence adduced by those 5 witnesses are part of the record? No.
I'll check up and I will.
Lordship, that
If
is
not
present in the-
available, you obtain the certified copy and produce the same before this court on next day. You.
Lordship, I'll-
Heard Ms. Sultana, learned counsel for the petitioner. Mr. Kyle, learned standing counsel for the respondent. NCB. Heard in part, place the matter on Thursday at 2 p.m. So you come with all those data on which that the witnesses did not turn up, and which that the prosecution side did not take any step.
Certain matters for hearing items 16 and 17.
But I beg apology, Miller, when the matter was called up, I was not
Okay,
there.
all right.
It's a simple matter.
But actually, I was supposed to some accommodation at the point of time, I could not appear, the first call. Little accommodation, I have already spoken to my other mother.
Issue is very simple, my lord. I'm praying for a, my lord, similar order that has been passed by the Assam Administrative Tribunal and which was subsequently upheld by this honorable court. Now, and the facts are like, my lord, we were initially appointed as lecturer in 3F. Thereafter, we were regularized. And thereafter, we were promoted to super time scale and selection grade. While granting this promotion, my lord, they did not recon the 3F service. And UGC regulation I have annexed, my lord, it provides that that period has to be counted. So this is the small issue, my lord.
So the 3F period has not been counted
Yes.
while regularizing your service.
No, while, my lord, while granting us promotion to super time scale and selection grade.
Okay.
So that is because the ultimate effect will be those 2 promotions will be antedated by 2-3 years. That is the effect. And that grievance was the tribunal, Assam Administrative Tribunal. The Assam Administrative Tribunal, my lord, directed for counting that service and they have implemented also. But while implementing, they said that it will be confined to those petitioners only, not to us.
No, that cannot be.
That cannot be. That is the
cannot.
case. And Assam Administrative Tribunal order has been challenged before this court and this court upheld. That is a simple case, my lord. My friend, my lord, Mr. Kostov Gogoi, he called me that second half he will not be there. Any date on Tuesday, my lord. Next Tuesday, my lord. That is the small and simple issue, my lord.
Okay, all right. Okay. As agreed by learned advocates of both the
Tuesday.
parties, recess and lays the matter on.
Oh. 27, my lord.
27 may not be possible. 15 চনৰ matter, old matter. কোন তাৰিখে গ'ল? On which that both of you will be available?
My lord, after 25, 27, 28.
No, then 27, 28 may not be possible.
Yes.
Let it be on December 2nd.
2nd December, fine, my lord.
2nd December.
Fine, my lord.
Fine. Okay. 2nd of December as parted.
Highly requested.
For hearing.
Lord, I'm extremely sorry. I beg to apologize.
no problem.
Happens. I know that this last time it is also hard, Lordship.
Mm.
So actually my submission before this honorable the court, Lordship, this trial court in the RCT,
Mm.
it is heard by single judge, Lordship.
Okay.
So as part of Supreme Court, it should be heard by division bench,
Division bench.
Lordship.
Mm.
And the similar order passed by this honorable High Court
Mm.
is the and it is elaborately stated in the judgment, Lordship, in the Supreme Court also.
That decision of the Supreme Court is with you now?
Lordship.
Decision of the Supreme Court is available with you?
Yes, Lordship. I have it. Judgment. Fine.
Which paragraph is relevant?
This is my lord.
Para number?
Paragraph, Lordship. Lordship will find this next page, page number 2, paragraph 3, Lordship. Paragraph 3, middle part I am reading, Lordship.
Yes.
The Parliament, 1, 2, 3, 4, 5, 6, 7, line number 7, the Parliament.
Got it.
Got it, Lordship. The Parliament then enacted the Administrative Tribunal Act 1985, providing for the adjudication of such disputes and complaints, though the tribunal established under Section 4 of the said Act, Section 5 within bracket 1 sets out the constitution of the tribunal and adds that the jurisdiction, powers and authority of the tribunal may be exercised by bench thereof. Subsection 2 of that section next provides that a bench shall consist of one judicial member and administrative member. This is very important. No provision to the contrary is shown to us. It is therefore statutorily recognized that every bench of the tribunal must consist of a judicial member and an administrative member. It is therefore obvious that the administrative member alone could not have heard and decide the matter. This is the Supreme Court Lordship. It is specifically stated that the tribunal has to be consist of the
one judicial member and one
judicial member and one administrative member. But in this case, in the instant case, here only one judicial member has decided the case.
Okay.
There must be a division bench, Lordship. And on the basis of this judgment, Lordship, this judgment in Honorable High Court of our and this Honorable High Court of the Gujarat also passed this judgment.
But this was in respect of
Lordship.
administrative tribunal.
Lordship.
But in our case,
Lordship.
it is the railway tribunal.
Lordship. In every tribunal, Lordship, it is Supreme Court stated that in every tribunal it should be consist of, because in the railway tribunal also two benches required, Lordship, one administrative, one judicial, Lordship.
No, if it is there in the administrative tribunal
The
act
Railway Acts also it is there, Lordship.
provided.
Lordship.
Okay. Railway.
Railway Claims Tribunal Act 1987. Page number 4, Lord.
Page number 4.
Case number 4, establishment of the Railway Claims Tribunal, Lordship 4, composition of the
Composition,
Claims
yes.
Tribunal and benches there. Let's see got it, Lordship.
Yes.
Number 1, the claimant. Number 2, subject to the other provisions of the Act, a bench shall consist of 1 judicial member and 1 technical members.
Yes, madam, what is your stand?
The interim judgment and order dated 2/9/2016 was passed by the Honorable Chairman of the Railway Claims Tribunal, Lordship. And the Chairman of the Railway Claims Tribunal is empowered to adjudicate the matter singly in terms of section 4, subsection 4 of the Railway Claims Tribunal Act 1987. This submission was already made in my previous occasion, Lordship. Therefore, Lordship, the Lordship have directed them to take action whether there is any judgment so far as the power of the chairman is concerned in deciding the claim applications. This was the submission made by me, Lordship, earlier occasion. That is on 15/7/2025. That is why this matter was kept in part further. So my submission would be, Lordship, the interim judgment was passed by the Honorable Chairman, and as per section 4, subsection 4, Lordship, if Lordship permit me, I would like to.
Yes.
Notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authority of the claims tribunal in respect of such classes of cases or such matters pertaining to such classes of cases as the chairman may by general or special order specify. Here, Lordship, subsection 4 says that the chairman can allocate cases to the member technical as well as to the member judicial, and such order should be their, Lordship, so far as the power is concerned, Lordship. So here, when the chairman has the power to allocate the matters to any of the member, whether it be member judicial or member technical, then the chairman itself has the supreme power to adjudicate the matters singly order. So, and second thing, Lordship.
No. Is it the language of the subsection 4?
Lordship, if Lordship see, Lordship, section 4, 4(1), Lordship, the claims tribunal shall consist of a chairman, 4 vice chairmen, and such number of judicial members and technical members as the central government may deem fit, and subject to the other provisions of the Act, the jurisdiction, powers and authority of the claims tribunal may be exercised by benches thereof. Subject to the other provision of this Act, a bench shall consist of 1 judicial member and 1 technical member. Notwithstanding anything contained in subsection 1, the chairman A may, in addition to discharging the functions of the judicial member or the technical member of the bench to which he is appointed, discharge the function of the judicial member, or as the case may be, the technical member of any other bench. B may transfer a vice chairman or other member from one bench to another bench. C may authorize the vice chairman or the judicial member or the technical member appointed to one bench owner to discharge also the function of the vice chairman, or as the case may be, the judicial member or the technical member of another bench. 4, notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authority of the claims tribunal in respect of such classes of cases or such matters pertaining to such classes of cases as the chairman may by general or special order specify, provided that If at any stage of the hearing of any such case or matter, it appears to the chairman or such member that the case or matter is of such a nature that it ought to be heard by a bench consisting of two members, the case or matter may be transferred by the chairman.
You tell me whether any general or any special order is passed by the chairman in this case?
No, because here the chairman itself has passed this order, Lordship.
Which order? This order?
Yes, Lordship. Lordship may kindly turn to the page, the last page of the judgment, Your Honor. The-
Okay, it was passed by the chairman, that's all right.
Yes.
But
There is no special or general order passed by the chairman, because the chairman himself cannot appoint him, Lordship, as a judicial member, because he himself is a judicial member, and I have a decision of this the Honorable High Court of Gujarat, which is upheld by the Honorable Supreme Court. This is a matter pertains to Railway Claims Tribunal, Lordship. Here the Honorable High Court, Gujarat High Court held that, Your Honor, Lordship, the order is final from this order. Para 6. This judgment is pertains to Lordship Railway Claims Tribunal Act 1987. The case is with regard to railway case, Lordship. Para 6. Given the coordinate bench of this court, while deciding the special civil application number so and so on 24/7/2013 has observed as under. Both orders have been passed by the single administrative member of the tribunal. Controversy whether single member can decide the matter or not. The similar question has been decided by the apex court in case of State of MP versus B.R. Thackeray and others in 2002 10 SSC 338 and held that the case involved question of law and its interpretation should be assigned to division bench of one of the members should be a judicial member. In para 3 of this judgment, the apex court has held as under. 3. Even assuming that all the powers of the tribunal could be exercised by any single member, it can only be by a judicial member of the tribunal and not any other member under the aforesaid order. From the aforesaid decision of the apex court, it is clear that since question of law and interpretation is involved, the single member of the tribunal cannot hear and decide the way, and subsequently, since he was administrative member, he has no jurisdiction to decide the matter singly, as only judicial member in some of the cases can decide the matter singly. Here, Lordship, emphasis must be given to this last sentence, Lordship. Though, since the member, administrative member, he has no jurisdiction, but the judicial member can decide the matter in some of the cases. So, Lordship, here, the judicial member is the chairman, Lordship. He has the power to decide the matter because he himself is a chairman. He is in a position to appoint member, technical and judicial members. So, Lordship, in my view, Lordship, this influence judgment passed by the honorable judgment is, Lordship, is a good in law, Lordship. It comes from section 2, Railway Claims Tribunal Act 1987. And here, Lordship, the case may be decided on merit because here the issue is fairly covered with the decision of the Honorable High Court, Lordship. I have prepared a written argument, Lordship, which I would like to place before Lordship and the judge.
now whether you are ready to argue the matter? Yes,
Lordship.
you are ready to argue the matter on merit.
With due respect, I am submitting one thing. Lordship, if the matter is, Lordship, done for the trial court, because on merit they will decide the division bench what is wrong. I'm nothing saying, because trial court is the appropriate court to decide this thing properly, because they have the every documents and everything. They can take also the evidence also there sometimes. So division they can form there because it is everywhere. It is specifically written. Division. It is a double bench is required. Division bench is required.
No.
Friend, it is now it is read out.
No.
Here also. Some
Whether-
special
no, no.
case can interfere.
No, no, you say discretion is given to the chairman.
Some special case, Lordship. No every case. Some cases, some special cases. Right now, my learned friend read out.
Kids, some special cases.
Yes.
Member technical or member judicial.
Yes, some special cases, not every case, Lordship. That is why Supreme Court emphasizes that there must, yeah.
City order. So that order may be passed by the chairman itself, Lordship, because he is in the discussion, he is in the power, Lordship.
No, you have already told this court that there is no such order.
Yes.
Yes, in the present case, there is no such order, Lordship. But Lordship, my humble submission before your Lordship, because this matter pertains to Lordship 2016, Lordship. It's a very old matter.
No problem, only
If
thing,
the matter
because
is remanded back to the tribunal, Lordship, a clear direction may be given to the tribunal.
Yes.
So with a limited time, Lordship,
Sure.
this matter may be.
Okay,
decided.
yes, last occasion it is given only 3 months.
Yes, sir.
Last occasion it is given 3 months, no problem.
Okay, 3 months.
Yes, 3 months, 3 months is enough.
That this matter be placed before the division bench,
Yes.
comprising of member technical as well as member.
Yes. And within 3 months, Lordship.
Within-
Matter may be decided within 3 months.
That may be decided.
Yeah.
Within 3 months from the
Yes,
date
Lord.
of receipt
Yes.
certificate copy
Yes,
of this order.
Lord. Yes. তাতে করলে ভালো
Any other matter?